Are we good? Well, I spoke with you. I know that. All right. Good evening, everyone, and welcome to the August 18th, 2025 regular meeting of the Township of Montclair Planning Board. In accordance with the New Jersey Open Public Meetings Act, adequate notice of this meeting has been provided by posting a copy of the notice on the first floor of the municipal building and by sending a copy to the newspaper designated by the township for notices. This meeting is being broadcast live on Channel 34 and is streaming live and will be available on demand on YouTube. This meeting is a quasi-judicial proceeding, meaning that the board has powers and procedures resembling a court of law, and we are obligated to objectively determine facts and draw conclusions from them in order to provide the basis of an official action. Any questions or comments must be limited to the issues of what the board may legally consider in reaching a decision, and the decorum appropriate to a judicial hearing must be maintained at all times. Fire exits are to my right, which is your left, and also at the back of the room where you entered. And as to the order of the evening, each application hearing, and we've got 3 applications on for tonight, although one is not necessarily a hearing, but each application hearing begins with the applicant or their attorney giving an overview of the application and the variances that are required, if any. We then hear from any expert witnesses the applicant may have to help explain the application and why variances are required. The board members may ask questions of the applicant, the attorney, and their expert witnesses. And if you're a member of the interested public but not a witness in the case, you'll have 2 opportunities to speak at each application. At the end of each witness's testimony, you'll be given the opportunity to ask the witness questions about his or her testimony. So at that point, it's only about questions about the testimony. It's not the time to tell the board what you think of the application. That actually comes later. So to ask questions, you'll have to come up to the front of the room, give us your name and address, and then ask your questions related to the witness's testimony only. And after the applicant's witnesses and any objector or objector witnesses have been heard, the members of the audience will then have their second opportunity to step forward. And at that time, you may express your opinions, positive or negative, about the application. And comments are generally limited to 3 minutes per person. And after the completion of the applicant's case and public comment, then the public hearing for that application is closed and the board members discuss the case and vote. And at that point, you'll be able to listen to our discussion, but will not be able to participate. And first up on the agenda is roll call.
Mayor Basford.
Present.
Mr. Borshoff.
Here.
Mr. Campbell is excused. Vice Chair Graham.
Here.
Mr. Ian Wally.
Here.
Councillor Lockman.
Here.
Mr. Fillets.
Here.
Ms. Willis is excused. And Mr. Neiman.
Here.
And Chair Brodock.
I'm here. Next up is swearing in of our board professionals.
Do you solemnly swear or affirm that the testimony you may give tonight will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
I do.
Thank you.
Thank you. And next up, we have approval of our minutes from the July 21st meeting.
I received amendments to the minutes from the chair, and they're pretty self-explanatory. Are there any other changes to the minutes? Is
Right,
there a motion?
I would move approval as amended.
Second.
All in favor?
Aye.
Opposed? Abstentions? Okay.
Next up, we have the resolution for 665, 679 Bloomfield Ave, which was Kush Connection.
I did not receive any changes to the resolution. Is there a motion to approve?
Yeah, so moved.
Second.
All in favor?
Aye.
Opposed? Abstentions?
Abstention.
Abstain.
Okay.
Next up is the resolution on the amended 4th round housing element and fair share plan.
Okay. Oh. Is there a motion to approve that resolution?
So
you have a-
moved.
do you
Can I
have
just
a-
ask a question? Yeah, I know, Janice, you say there's 132 units that are rehabilitative need, right? But you don't explain that those are offset by the credits that we have in the bank, so to speak.
That's
So-
in the plan.
Yeah.
It's not in the resolution.
No. So if somebody was reading this just, 10 years from now, they'd think that we had to do 132 rehabilitations, where in reality, we don't, correct?
Well, our plan addresses the 132 unit present need obligation in full. So perhaps we can add a statement saying that the plan addresses that obligation in full, so we say it up front.
Yeah, something like that, or explain even why that we don't have 132 units, because we have more or less credits in the bank
Right.
that wipe out that need. I mean, I would say that, I don't know if everybody else would, not like that, but you get
I
the gist
understand
of what
what
I'm saying, yeah. Just so it's clear from this document exactly what's going on.
Okay.
I don't have an issue with that.
So, do you want to figure out what you're going to say so we can vote on this?
I would say, I think we've already, I'm on page 4.
Right.
The second, where the first, be it further resolved. I don't think we need to make that statement that we reconfirm its acceptance of the obligation of 132 units. Why don't we just replace that sentence, that the board hereby adopts the fair share plan that fully addresses the 132 unit present need obligation through application of existing credits. So the housing obligation is fully met.
Yeah. That
That work?
Yeah.
sounds fine to me.
So moved.
Thank you.
Second.
Mayor, you made the motion?
I do.
Okay. And all in favor?
Aye.
Opposed? Abstentions? Okay.
Okay. Next up, we have application 2392, which is 161, 167 Glenridge Avenue.
I was just going to say on advice.
Is your microphone on?
But on the advice of counsel, I am, to avoid the appearance of any conflict, I'm going to recuse myself from this application.
Okay.
Okay.
Good evening, Mr. Chairman. Gregory
Evening.
Massara. Gregory Massara, Bannon Roding, McDonald and Massara, on behalf of Glenridge and North Willow Company, Inc. Mr. Chairman and members of the board, this is not a formal application before the board. This is a request for the board to affirm the approval of a planning board decision that was made December 7th of 2015, memorialized by resolution on January 11th of 2015, subsequently published on January 21st, 2016. What has triggered this appearance this evening is one of the principals of the owners of the property, Glenridge and North Willow Company, appeared in Ms. Talley's office and requested that Ms. Talley issue a letter in favor of the applicant's lender that all permits are current and that the applicant can proceed with this application. Now, given the dates that I have just mentioned, this appears to be somewhat stale, excuse me. But what happened was in 2017, the owners did apply for and obtained building permits to construct the footings of the proposed building on the property. Those footings were indeed constructed and approved by the construction office. In 2021, an amended application was submitted to modify some of the footings, and those permits were again issued. Everybody knows what happened in 2020 and 2021, and COVID had a severe impact on this applicant. The principal of the applicant, Alphonse Cuoco, suffered 2 severe bouts of COVID, hospitalized for over 30 days on 2 occasions. But as importantly, for purposes of this hearing this evening, the construction financing disappeared, as did a lot of construction financing in many projects. The project has stood still since that time. Construction financing is now in place, and it is simply waiting for the lenders to know that permits are in place and that the application, the project can move forward. I had corresponded with Mr. Neese, who was kind enough to very, very promptly reply to a letter that I had submitted to Ms. Talley and requested that Mr. Neese opine that the application was in good order and that my client could proceed. Mr. Neese raised some questions as to whether, in fact, we are entitled to proceed. And I'm here tonight to suggest to the board that the applicant is very much prepared to receive and respectfully is entitled to proceed under, with the approvals that were granted initially. Case law suggests that once there is substantial reliance on a final site plan approval, and substantial reliance is undefinable, it is something that every case should be weighed differently. But case law is clear that, in my opinion, that when footings are set on a property, that meets the criteria of substantial beginning of completion of an application. I can say case law also says that if an owner simply did footings, did boreholes to test soil, that is not enough, but that it would be a balancing test. And secondly is that reliance matters. The owner has relied upon the permits that were issued in the first instance and proceeded, and based on the issuance of those permits, went and proceeded with the footings. And then, again, unfortunately, the project has stalled. Mr. Neese also pointed out, I need to say that initially, Montclair Ordinance 202-20 says an applicant must begin the building process or the construction process within 1 year of initial approval. Mr. Neese pointed out to me that the applicant waited 18 months until they got the initial permit to proceed. However, the permit was issued by the township. The reason for the delay, we believe, and this is speculating, was that there were post-approval conditions with regard to the aesthetics of the building. And the owner worked with professionals in the township to modify some of the exterior of the building. That aside, the permit was issued by the township, was substantially relied upon by the township. So the threshold issue of, hey, we only had 12 months to apply for initially after approval, once the permit was issued, whether rightfully or wrongfully, there was reliance on that, and there was subsequent work done. So there's two issues: the first threshold issue, which I think we easily meet, and the second issue, which I think we easily meet as well. And I just want to add one more point. Up through 2024, the township continued to take from the applicant's escrow account, because there were continued, usually semi-annually, there were inspections of the property, and engineers were paid for that inspection, and the escrow account was deleted by the amount of the engineer's fee. So the town also had this as an active application or an active project. So we're here tonight. I think Ms. Talley, in her capacity, raised a legitimate question and asked for clarification. Mr. Neese issued an opinion. I can't really say it's an opinion. I don't want to speak for Mr. Neese, but raised legitimate questions. And I think we've adequately answered those legitimate questions to have this board confirm that, or affirm that the application is current, or the project is current, and that we may proceed.
So tell me more about the delay in 2016 into 2017. You said you're supposing that there was some discussions with the township.
Well, there were post-condition, there were post-approval conditions. And there was discussion afterwards for a long period of time about the aesthetics of the building. And that took some time. Respectfully, Mr. Chairman, like, the fact that the permit was issued 6 months after the 1-year deadline, and that permit was relied upon, and then footings were poured and subsequently approved, then, that is not really something I think that this board can revisit to say, well, that permit should never have been issued 6 months after the 12-month deadline.
Mr. Neese, let me just, Mr. Neese, is that your interpretation of the law?
So the case law that I was able to find says that where the township or a municipality has a provision in its ordinances concerning a time constraint, it has to be honored. I mean, it's the law of the town. That said, the case law does say that that time constraint is not dissimilar from the board's consideration of a variance. That is to say, variances run with the land, and if something changes along the way, the board would be able to revisit it. I think the bottom line that the cases say is that if the delay is justified, and I was just trying to find the actual language, if the delay is justified and it's satisfactory to the board, I mean, look, this applicant came before this board in 2016 and put on and wants to build a substantial project, and now is coming before the board and saying, we want to continue that project. I think from my perspective, just as a person, if the board were to deny that application, it would be punitive more than anything else. So council has suggested that there are rationales for why they were unable to begin. I just spoke with Janice, and apparently there were appearances before the revisions committee of this board subsequent to the adoption of the resolution. So it rests within your sound discretion at the end of the day.
Well, I guess I was wondering, is council suggesting that because the township issued a permit, that they're entitled to rely on that permit, and it almost sounds like we have no choice but to say, go forward with the plan,
I'm
and
not
that's what I'm just trying to understand.
I'm not suggesting that you have no choice, but what I am suggesting is if you believe, and maybe perhaps this is Mr. Neese's advice, but my position would be, if you believe that there was reliance on the permit that was issued, and that reliance was substantial reliance, which I'm suggesting it is, because footings were poured, then that weighs in the owner's favor. But that is the question that needs to be answered, whether there was reliance. And as Mr. Neese, I'm sure, could supplement, there is a line of cases that speaks of, in different settings, but that speaks of a zoning officer or a construction code official issuing a permit in different circumstances, reliance on that permit, and then the township or municipality attempting to pull the permit or revoke the permit. And substantial reliance is a key in those cases. There's a classic case where there was a setback that was off by a foot or less, and the township tried to revoke the permission, and the home had already been built, and the court ruled that no, there was substantial reliance, and the equities, as Mr. Neese had suggested, the equities were in favor of the person who relied upon the original approval.
I would just say that in cases like those, it seems to me that what is being considered are variances, setback variance. I think you just named that.
Right.
Here, however, it's a little bit different because there is an actual ordinance that defines what conduct is supposed to occur within that year period. I think if we were to go to court over this, and I'm not suggesting for a holy second that this matter go to court.
Right.
But if we were to go to court, I think it would be a difficult thing for a Superior Court judge to decide. Well, the ordinance says if you don't build, and if you don't start, if you don't do something meaningful in that first year, the town is within its rights to say, well, it's not something we should do. And that case is Ramsey Associates versus Board of Adjustment of Burnsville.
But the permit here was issued.
No, I understand that.
Right, so that, and, you know, variances are by ordinance also. So we're always talking about the violation of an ordinance.
But the
whether it be-
variances are granted based on proofs that are submitted to the board. In this case, there's an actual ordinance that says thou shalt do something within that first year period. I don't want to continue, I don't want to have an argument about that.
Okay.
The point is that if you look at it from 30,000 feet, this could go either way. At the end of the day, as I said moments ago, it really is within the discretion of this board to decide whether the proofs that have been submitted to you in the form of statements from counsel, there's no real evidence here, it's just statements of counsel, if those appear to you to be satisfactory based on the nature of the application, the time, what happened, it's within your discretion to decide how to proceed.
And Mr. Chairman,
yes.
if I could just summarize. The applicant, the owner, is ready, willing, and able to construct a building that will beautify the area, that was justified in an application that was memorialized specifically by resolution. I'm not sure whether Mr. Neese wrote it or someone else, but
did.
It's a great resolution. It's thorough. We have.
just
Are you, I would say, are you
He's
saying that just because he wrote it?
Whoever wrote
Really
it
is. I mean,
was highly
he's
intelligent.
already, I think he's already said he doesn't want to argue, so. The applicant is ready to build the building that was approved. It will be certainly an enhancement to the community. It certainly has been dormant for too long. Financing is now in place, and I think, you know, the area will definitely benefit from moving forward at this point and hopefully getting a building ready for occupancy in the very near future.
Mr. Ian Wally, you had a question or comment? No, get to you.
Thanks. Martha's letter, the board does not agree that there's.
Your mic's not on.
Yeah, sorry, I do that all the time. The board does not agree that there's been continuous progress toward implementation of the approved plan. That's in our ordinance, continuous progress? Because we were speaking about this one-year thing. I just was wondering if I could get some clarity on that.
That was in quotes. Continuous progress toward implementation of the approved plan.
Where does that come from?
That quote came from Mr. Macera's.
Oh, so it's not a, okay, so basically we had that 1 year, okay.
If I could, Mr. Rainulli, if I could address that issue, there is a case that also says that when a township, I think that's the Sawto case, S-A-U-T-T-O, that when a township desires that continuous progress be made, that it be in the ordinance. That the township has a deadline that says, okay, you have 12 months. The township could also have in its ordinance, and that you must have continuous progress, and that's, you know,
So that's
certainly
not
amorphous,
in our ordinance.
But that is not in the ordinance.
Okay, I just wanted, that's all I wanted to
Right.
clarify,
No.
okay.
Right.
So then you had a year, and then you needed another 6 months.
Yes, and.
So why, what was involved in making revisions? You mentioned let me just tell you what I'm getting at. We were given plans of the building dated September 15, 2016. I'm understanding there's been revisions after that date. So we've been given, I guess I just want to make sure that whatever we say yes to, we're saying yes to what it is that's being approved, because we've got a distribution of plans that predate when supposed changes were made to the plan.
Understood. They
So-
were approved. There was approval conditions.
Do we have, do we know what the finished drawings are?
I think there was, in my file, there was a one-sheet page that showed some changes. I didn't give that to the board because it doesn't fully explain the project. So there was work done post-approval, which happens with almost every application, and it was probably minor. I believe it was changing the layout of some of the rooms that the board had asked for in the resolution. So I don't have those details, but it was not major. And I didn't give those to the board members because I really wanted to give you a flavor of what was approved, because a lot of you weren't even here in 2016.
And Mr. Ionola, if I could address also your question, I believe that council has said that statute 55D-52 does not apply. That's the statute that allows the owner, after receiving site plan approval, to apply for 3 additional one-year extensions. To go back to the permit being issued 6 months later, if that permit were not issued because the 12 months had run out, then a case could have been made, again, based on the facts at that time, a case could have been made and an application could have been brought before the board to say, hey, time has run out, pursuant to 4055D-52, provided we meet some of the criteria in that statute, such as administrative delays or whatever, we are entitled to an extension. So we didn't have to do that because the permit was issued. Had the permit been denied, then presumably then an extension would have been requested, and in all likelihood, I mean, I've never been in a situation where a permit was not extended with facts backing it up.
Now that you're ready to go, has the architect and the engineers prepared construction documents?
The construction documents are not prepared yet, but they are, again, the financing is in place, subject to this, and COVID was a substantial impairment to now granted that was 3 years ago now, but Mr. Cuoco was gravely ill on 2 occasions with COVID. I mean, they are ready to go, and in fact, subject to Mr. Neese's approval, if the board is inclined to put a timeline, nothing would prevent the board, in my opinion, from saying you must meet, this deadline by, otherwise this approval will be revoked. I think my client would consent to something, that is reasonable in that regard. I mean, we're not here just to, and I'm not suggesting by any means that you're suggesting that, but we're not here just to keep it alive. We're here to now go.
I just want to clarify. The reason I said that 52 did not apply, Article 52, is that in D, subsection D of that section, it says, if the developer proves to the reasonable satisfaction of the board that the developer was barred or prevented, directly or indirectly, from proceeding with the development because of delays in obtaining legally required approvals from other governmental entities, and that the developer applied promptly and diligently pursued those approvals, end quote. That's the reason.
I agree with you wholeheartedly. I was just
You agree with
suggesting
the law, is that what you're saying?
the first 6 months I was speaking of, that had that permit not been issued, I'm not talking about now, I agree with you now, but during that first 6 months, if the delay was indeed because of post-approval conditions that they were trying to meet, then I think that would have been satisfactory to have the extension granted then.
Vice Chair Graham.
So after the permit was issued, there's approximately 2 years, a gap until the footings are installed, correct? Is there any statutory issue that we need to deal with, the fact that construction was not started for 2 years? Is there any requirement that work be done within a certain time period?
No, and that is what I was suggesting before about your ordinance. There's no statutory guidelines
Just
or
wanted that
requirement,
clarified. Okay.
nor does your ordinance say, that you must proceed diligently or anything as vague as that.
So then after that 2019, there's no further requirement. I think it was 2024 was when the next work was done, right?
There was an amendment in
Soil
20
conservation?
No, 2021, there was another permit issued to modify the previous permit, and that's when the footings were ultimately completed.
And they're completed in 2021?
Yes.
Okay. Thank you.
Councilor Lockman.
Okay. I guess I have a different point of view maybe than the legal issues or the legal statutes may dictate. Number one is that you've been like futzing around with this since December '08. That was when a similar application was sent and approved by the planning board at that time. So that was in December '08. Then nothing happened. You put in these footings. I'd love to know what, you say it's substantially beginning the project. I'd love to know what was the material, what's the material cost, how does that relate to the overall cost of the project to say that you're substantially beginning this project. I don't believe that's true. I believe that the footings are probably in there to keep the project alive. I think that since I guess there's many things that have happened in town that would affect this project. For example, we had an ordinance that lowers the heights to 3 stories on that Glenridge Avenue corridor. There's a 20% affordable housing requirement that if you don't submit a new application, you rely on what you've already submitted, none of that would apply. And I believe that the intent of this council and planning board was to lower the heights on Glenridge Avenue. You had an empty lot that sat there in the center of our business district for years as an eyesore. Whether that has any legal ramifications, I don't know. But every time I passed that lot, I said, oh my God, what's happening here? And when is it happening? And you'd see a couple of little concrete posts. I don't think that's a substantial beginning to building a 5-story building. There's also been a lot of change in that area. Right across the street from you is a big building with substantial cars. You're saying you're relying on a traffic study that was done ages ago, where now we have Seymour Street, we have a parking deck, we have Viva Lounge was changed. As I said, the Willow Lofts. All of that has changed. And you're saying that you want to submit this exact site plan for approval now?
No, we're not submitting
Well,
this.
I know you're not, but this is what you're relying on. You're
Okay.
relying on this resolution that outlined exactly what could be built there. So I am, let's see, is there anything else here? I think that's all I can come up with for now, but I am outraged
Okay.
that you think that you should come here and submit something very similar to what was submitted in 2008.
Well, in 2008, if you recall, the economy totally crashed, okay? We are not here tonight seeking anything with regard to 2008. That's why the applicant came back in 2016 and made a new application,
Right.
okay? We are
And then
talking.
sat on it for 10 years, yeah.
Okay, as I had advised the board, it was not sat on for 10 years, respectfully. There were footings that were constructed. There was a permit issued. Okay, so, I mean, that's what we, as the owner, have to do, in my opinion, to meet the criteria of why we're here tonight, to have this affirmed. You are entitled, obviously, to disagree, and it seems that you do disagree.
I do.
But this is not a revisit of the original approvals. This is to say that we relied on the approvals and substantially enough to meet the criteria in New Jersey case law. There is a case in New Jersey, and I believe it's the Gulf Oil case, where the court ruled, that's a Supreme Court case from 1960. And these cases are very, very old because they have held water all this time, 60 years or so. The Gulf Oil case said that it could have been Tremarco, one of the two, but we're not here to, this is in a court of law, but, counsel, I'm sure will look at it, that said demolition, beginning of demolition by removing pipes and interior walls was substantial work to show reliance. So that is something that the Supreme Court of New Jersey has stated, that beginning that, not even demolishing a building. So there is obviously, a spectrum of what is substantial compliance and what is not substantial. If you believe that putting footings is not substantial compliance, then I can't argue with you on that. I respectfully disagree, but, you're entitled to that opinion.
You're talking about commencement with that case, right? Not substantial reliance, right? Isn't that,
No,
isn't
that
that
was,
case
that
about
was
commencement?
that was substantial reliance.
That's
Which case,
Yes.
Gulf Oil?
This is Gulf Oil
Gulf
v.
or Tamarco?
I think Gulf Oil is the right one.
Right,
Gulf Oil v. Vogel.
yes.
Yes.
I think that's the right one about demolition. And
That was a building permit case.
You're right.
I'll just read the first paragraph, you'll get the flavor of it.
Please do.
Quote, "The question here is whether a building permit issued by the defendant building inspector of the city of Rahway had expired because no work was commenced under the permit within 6 months after its issuance as required by the building code of the municipality. The conclusion of Judge Hetfield in the Law Division was in the negative. The building inspector appeals, and the Law Division was affirmed," which means that could do it. He was, just because the building inspector said there was no work, they still had to issue the building permit. That's all that says, that case.
Well, if I could read directly from the case.
That's what I just did.
Okay, where the question is whether any substantial overt act had taken place on the premises material to the effectuation of the project and manifesting to the municipal authorities on inspection of the premises that the work is going forward. In this case, such acts took place with the dismantling of the pipes and the stripping of the fixtures of the old building, as well as removal of shrubberies. So, Mr. Chairman, basically they run hand in hand, commencement and, commencement has to be substantial.
I'll just continue that case, by the way. Quote, "We ought not be astute to find a forfeiture of rights under the building permit when it appears that the owners have in good faith been proceeding steadily, although slowly, with the project, and have invested substantially in preliminary arrangements." But that case was somewhat different because they came and said, this is what we've done and we're moving forward. In this case, you've relied, and I'm not taking a position one way or the other for the board, but in this case, you've relied on the fact that you put in footings.
Well, this is what we've done and we're moving
Well,
forward.
it's,
Well,
there's
To the point of good faith, why the delay of 2 years between the permit being issued and the footings being put in, and then the several years before additional action was
Financing.
taken? So financing in 17 to 19 they weren't able to obtain it? Because that's pre-COVID, where they were unable to.
No, I'm sorry, I thought you meant now. I mean, if the board desires, I could put Mr. Cuoco on and he can answer those questions. I was hoping we didn't have to go there.
I think,
It appears he's ready.
I think it would be helpful, yeah.
To tell you my story.
So
Sure.
why not?
Back there for the last hour, my feet have been burned, my mouth is on fire. I am so sorry that you wasted your time, with all due respect.
Can you speak
Yeah.
into
Yeah.
the
If
microphone?
you turn on the microphone, we'll swear you in. And
Sir, do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
Would you please state your full name and your affiliation, business affiliation for the record?
Alfonso Cuoco, owner, president of North Willow Glenridge Construction Company, Inc.
Mr. Cuoco, can you tell the board about the gap between 2017 and when you first got the permit to pour the footings, and then what happened thereafter?
Absolutely. So when we started pouring the footings and the foundation, we were originally going to go with a modular construction, okay? We got the financing based on modular. After we got the plans for the foundation of footings for the modular system, which is the block system, we found out that that was not going to, that the company that I was working with and the engineering they provided was not correct. The modular wasn't going to work with the footprint, okay? So we had to change. That's why we changed the foundation back in '21. We went through so many, can I tell you, back and forth with my architect, with my engineer, with the modular company. Finally, we scrapped the modular, and we decided that we would go with stick-built. Steel, concrete, frame. That's what happened. We had financing for the modular, okay? I've done other modular projects before here, Clifton, Passaic. And so the bank that I was dealing with was comfortable lending me the money to do the modular. When I explained to the bank and to, obviously, to the modular company, the bank said, listen, Al, we don't really get involved in that kind of thing. We just do modulars, as you know. Okay, so we got that out of the way. COVID happened, right? Now, if you think that nothing's going on, it's every couple of days you're on the phone with one engineer, you're on the phone with the architect, you're on the phone with the lawyer, because everything you say now is costing time and money. So it wasn't like I was waiting, and I apologize. So we did. We got the footings, we got the columns in, we got the steel in the ground. That was all inspected, and that's been there for years. And I'm sorry. I've tried to maintain the property. I want to see that done. COVID hits. I remember even Janice calling me up during COVID. Alphonse, you got to get started. I said, Janice, I'm scared. I said, I got COVID bad. I said, I'm scared. I'm scared to go out. I'm scared to go get material. I'm scared to meet in front of the guys because I was in the hospital. So I'm sorry. I am so sorry. If COVID did not happen, ladies and gentlemen, that building would be there today. It's cost me hundreds of thousands of dollars to keep that property vacant. Not because I'm losing money, it's what's costing me. So I'm not here to ask for forgiveness. I'm here because it just happened. And then for a couple years after COVID, no one would lend. We went to banks. We went to hard money lenders to the point where I was willing to pay 18, 19% with 4 points. Now, at $6.5 million, ladies and gentlemen, I might as well not build it. Things have gotten a little better now, and they're ready to give me the money. And that's why I came to talk to Janice and say, please, we're at that point that they can lend me the money. I can get this built. And with all due respect and with all guidance from you folks, I would have taken into consideration, I can have the architect start working on we're ready. Just, we need some money, the first draw from the bank, and then they can go forward. I can start giving the money to the architect to get the plans going. And I may even ask, and I think it would be awesome that you guys could be involved with making it more beautiful to what you think. This is one of the most rarest buildings built in the newer time in the construction of brick, true brick. It looks like Montclair. It is Montclair. That's why we went to that. And the original one in '08 was that ugly, disgusting EFIS, which would have been a disastrous health mold disaster now. It would have been an ugly project that you would have never wanted to see. You would have driven by it and said, please, why did anybody approve that? But in '08, it was all about EFIS. It was all about that stucco. And that's why I'm here today. I'm ready to go. I got my health back. I have my strength back. I want to get this built. I want to do this. I want to do it with your help. I promise. No more back and forth. I'm ready. Thank you.
Any question from the board?
Okay, so the construction drawings are yet to be done. Would you be able to, in a memo with a lender's letter, sort of saying, here's my financing package, and give the board some, you're telling us all this, have the lender identify themselves, your partners and so forth, and, because I think we're all set, and I think if you could formally present that to us.
I was going to bring it tonight, but
Well, we could delay and
I would ask that rather than delay, say that a date, by a date certain, we would, if you're inclined to approve it, by a date certain, if you produce it, then, the approval, rather than have to come back and then, reconvene.
What if it doesn't happen by the date
Well, then,
what's the downside to that?
then the board could say that the approval is not granted.
So it'd be a condition. right?
A condition of approval.
May I just say something? So much has changed in that area when this was first contemplated and then approved. As I said, this is a much taller building. 3 stories was what was approved since subsequent to their applications.
The zoning was changed.
Zoning was changed. Why doesn't the current zoning apply to this? That's what we're losing here, is the fact that our town will be affected by this another high building, the canyon effect between the 2 buildings because they're right opposite each other, the Willow Lofts and this building. The 20% affordable housing, this is what? It's 12%, I think I calculated it. If this were built today, you'd be required to have 20% affordable housing. The fact that we have looked at this hole in the ground since 2008, and it was called a blighted area. This is not a blighted area. We had the best real estate in a generation, with people stopping and randomly saying, I want to buy your house. So I find it kind of disingenuous to be crying about this, because I feel like this could have been done. It could have been, this is a great rental market, and yet you sat on this. And I understand your personal story, but you're more than just a person, you're a company, right?
No.
Well,
You're looking at
whatever.
it.
Then maybe, I don't know. But
This is
I,
still-
as a resident of Montclair, I really, really object to the fact that we would be looking at this same 5-story building with parking on the first floor in an area that we've already said should be 3 stories, and that now the parking is fine in your building, but the traffic has changed so much. As we have all this new development, new restaurants, a restaurant down the block, I just don't see it approving this to move forward with this.
Mayor?
Yes, Councilor Talley, can you verify the year that we first put in the 20% affordable housing? Because I recall under the leadership of Mayor Jerry Freed, which was in '08, we did have 20%, and I'm looking it up. So do you know the exact time when we first, not when we, reiterated it, because we did another reiteration and then we came back recently?
It was 2009. But what happened with
Okay,
this
that was during-
application,
yeah,
with this
yeah.
application, they got their approval in 2008.
Okay,
When they came back in 2016, it was an amendment.
okay.
So they were under the zoning from 2008.
Okay, no, because I knew that the 20% was
Right.
much earlier than most
Yes.
people understand,
Right.
because it wasn't adhered to for a long time, or
Right.
at least for 8 years. People don't understand that, but it was 2009. Okay, thank you.
Mr. Chairman?
Mr. Hernandez?
Yes, thank you. Question I have, and apologies because this application predates my time on the board, but were there any stormwater management measures included as part of that original 2016
Yeah,
approval?
Frank Matarazzo had all the calculations, and that was presented. It was in the original package with the footings and foundation permits, yes.
So there were
100%, yeah. they
some
wouldn't
kind of
have issued the
underground
permits.
storage?
Yes,
Okay,
yeah.
okay.
So question, since that time, there's also been changes in stormwater management. So
that's-
would they
that's-
have to adhere to the current regulations about stormwater?
So, correct, to the councilor's point, the township has made substantial changes to their stormwater management ordinances since the time of approval. However, the applicant would be required to comply with what was in place at the time of approval.
So despite the fact that there's been considerable changes in the
Correct.
law,
Correct.
they can go back to whatever
Correct.
date.
Sounds like 2008, actually.
Sound
from
does
what-
sound like
From what Ms.
2008.
Talley said.
No, the stormwater management was changed effective June 2023, and the application, that's New Jersey legislature. Anything before June of 2023 anything after June of 2023, I think, is the effective date. Anything before that, then the prior stormwater management regs would apply.
Well, there've been several, 2023, 2021
Well, 2023 is the last.
is the latest,
Right.
correct? But
Right.
prior to that, there was another amendment in 2021.
Right.
And I'm sure there may have been another prior amendment prior to 2021, which would have been after the 2016 approval, so.
2023 was the major revision,
Well,
though, correct?
one of the major.
Well,
yeah.
the very
Yeah.
major
Yeah,
revision.
yeah, the latest, I would say. So
So what iteration would they be required to follow?
whatever was in place at the
In
time.
08?
In, I
Well,
would say
I think-
2016.
Well, Ms. Talley's saying the time of application for this was 08. Is that-
2000, all I know is, yes, when they came in for 2000, for the amendment, they were based on the 2008 zoning ordinance. I can't recall how we applied the stormwater
So, well,
regulations.
prior to 2021, for non-major development applications, we would call it, which is an acre or more of disturbance, essentially the township did not have any requirement for stormwater management improvements.
And bear in mind, this is right next to Tony's Brook.
Well, on
you
top
know.
of it, yeah,
Mhm.
yeah. So,
It's actually, Tony's Brook runs through the property.
Correct.
Okay.
Runs around the
Okay,
back-
so it's
runs
right
around
on
the
top of
backside.
Tony's
On top
Brook.
of it.
So that could conceivably impact whatever they do on that site, the other properties around it. And we know we've had problems in that area anyway.
But there was no significant, based on the stormwater management calculations, then and now, there was no significant added to the drainage, because currently the property, and previously the property, was 100% impervious. So that means that building that was there, previously that burnt down, was 100% covering over it. This is not covering over the entire property anymore, thank God. It's only covering over less than half, so,
You mean the building?
the building,
Yeah,
yeah.
because you have parking
Yeah,
across the
correct,
park.
yeah.
property.
Mr. Chairman, if I respectfully, the purpose of this evening is not to revisit the application. The purpose of this evening is for the board to respectfully decide whether the applicant has moved forward under the case law and the requirements of the case law. And it is our position that the applicant, by starting and building the footings and doing the underground steel, has met that burden, and therefore, respectfully, is entitled to continue to move forward. This is not about whether it should have been granted, what has changed, whether it's significant change or not since that time. This is about what the law says, not personal opinion or anything of that nature. But under the law, it is our position that, again, respectfully, because it's up to the board to affirm, but it's our position that we have moved, albeit slowly, but we have met the requirements under the law to be able to proceed. And this is not, this is not to revisit the number of stories, the stormwater management. Importantly, as Mr. Cuoco said, the property was 100% pervious, but again, we're not going to the facts of the application. We're going to what transpired, and based on what transpired, are we allowed to continue?
No, I understand your position. I mean,
Right.
but you also raised the idea of conditioning this.
Well, about the financing, because
Yeah,
that
I-
was something that Mr. Iannulli had brought up, and that's something we're willing to do, no question, because it's in place.
Well, and
So-
then the board's asking questions about, what the application is, and perhaps there's
Right.
other conditions that the board would
Right.
consider, and that's
Right.
why they're asking these
Right.
questions.
But
Do you
but
need a
again,
moment?
the conditions, the conditions are not, the condition about the ability to proceed so there's no further delays is related to why we're here this evening. Conditions as to, will you modify the application? We are not permitted to do that tonight, because that would require new notice and everything. This is a non-noticed hearing. Procedurally, notice is not required here. But the condition, as opposed to the financing, has to do with the reason for the delay. So we're happy to prove the reason for the delay, but not to go back and revisit the massing of the building, the height of the building, et cetera.
So I just want to chime in here. I don't want to be overly technical, but the ordinance says, 202-20 says, any variance from the terms of the zoning ordinance hereafter granted by the Board of Adjustment, or in this case, the Planning Board, shall expire by limitation unless such construction or alteration shall have been actually commenced. And then it goes on. The applicant sought and was granted variance relief in connection with that application back in 2016. The resolution says a variance to allow a parking deck below the building, to permit certain parking spaces to be set back less than 4 feet, a variance to permit a fence to exceed 4.5 feet in height, a variance to allow for no off-street loading zone, a variance to permit less than the required number of on-site parking spaces, and there was also a de minimis exception from RSIS. But those variances were granted as part of the application. And if you read the ordinance, technically, it says any variance shall expire by limitation unless the construction or alteration shall have been actually commenced on each and every structure by said variance, or unless such permitted use has actually been commenced within the 1-year period. So, again, I don't want to be overly technical, but it is.
No, but that speaks to the question at hand here, right? It's been 9 years and things have changed in town. So there's a reason why those variances expire, and it seems that this is a reasonable scenario where they should be revisited.
Well, Mr. Graham, respectfully, the permit was issued. That's
I
not-
understand the
that's
permit
not-
was issued, but to Mr. Neese's point about the variances, right? What are we going to do about the variances? Things have changed substantially in those 9 years. Those variances, according to the statute, have expired, correct?
Well, how was a permit issued based on the approvals, and there was reliance on the issuance of those permits?
I understand that.
So the
and
town would be stopped from now trying to enforce its ordinance, and Mr. Neese can expound to the board on estoppel.
The permit issue to me is separate from the variance issue. I understand the variance being, I'm sorry, the permit being issued. I understand relying on it to start construction. But how can we say the variance requirements have been satisfied? I don't understand how we can make that argument.
Because we relied on the ordinance, on the resolution to proceed. We obtained a building permit based on the resolution.
With variances, correct?
Okay.
Right.
So if your suggestion is that variants expire, but a permit can still be issued, how does that make any sense?
No, I'm saying that I understand, I guess, tolling for purposes of issuing the permit, right? But does that then say that the variances run from that period on?
Well, variances tend to run with the land.
But do they run from the moment that the permit was issued, or did they have to complete construction in a year?
No,
Okay, so just to
ordinance-
clarify, I'm trying to get clarity here.
Right.
Trying to get clarity. So the point of this ordinance says that after that they have a year to issue the permit, and then the variances are.
No. This ordinance that's the subject of this discussion has nothing to do with the issuance of permits.
Okay.
All this ordinance says, and quite succinctly, any variance shall expire by limitation unless such construction or alteration shall have been actually commenced on each and every structure permitted by such variance, or unless such permitted use has actually been commenced within 1 year from the date of the publication of the notice of the determination.
So the issuing of the permit is separate from
Completely
the
separate.
variance requirements.
Right.
That's what I was trying to get at before.
That's correct.
Perhaps
There's nothing in
inartfully.
here about
Perhaps
issuance of
inartfully, but
permits.
that's what I was trying to understand better. So,
The ordinance number, is that 4055D 52, or is that a different one that you just quoted?
202-20.
Correct.
202-20?
Yep. And that's what I was trying to get at initially in this matter was, I read that, and, I respectfully disagree with Councilor Lockman about substantial commencement. I think putting footings in is substantial commencement in terms of what I've read in some of the case law, okay? And it's.
We could argue about that. You could measure substantial beginnings by looking at how much money have they spent on these footings
Sure.
versus how much they plan on spending for a $35 million five-story apartment building. And to me, it would be nothing
Right.
in comparison, or very little.
And
then, so is that substantial?
But it
I mean,
may
that's-
satisfy the
I-
case
I
law.
was going to say, I
Maybe.
understand that,
Yeah.
that perspective. I spent this blue book that Mr. Neese has up there, I spent way too much time this weekend reading it. Yeah, I was trying to understand, what are
and
some of the
affordable
issues here?
hou-
Just one quick second. And so, that's what I've been grappling with, is this issue about the variances expiring because of limitations, expired by limitation, unless construction has been actually commenced on each and every structure. I think that they have commenced. It has commenced construction on each and every structure. But where I'm struggling is that year where the variances would have expired or should have expired a year after the publication. You're saying that doesn't really apply because you got a permit anyways.
Because we relied. And the other thing is, from an equitable standpoint, had the permit not been issued because a variance expired, under the statute, Section 52, we would have had the ability to request an extension, and based upon the reasonable delay because of the difficulty in getting the final plan, we believe that extension would have been granted. So it's almost like, now, yes, it is 10 years later, but in 2017, we would have requested
I don't think so.
the extension of
I don't think
the
so.
site plan approval.
You know?
I
So-
see what you're saying.
Right.
But that's
Well,
not
that's
necessarily
where,
what
that's where,
happened.
that's where equity comes in, and the town and the municipality being stopped from preventing this, in that regard, from moving forward.
Can I ask, Mr. Mancera, what is the nature of the reliance that you're attributing to this applicant? What is the reliance?
That we
That
applied for the building permit
They just
and
got a
built the-
building permit?
And built the footings.
Okay, yes, but that's the sum and substance of the reliance of the applicant.
Well, and just continue to move forward with the attempts to
Get
to sell the property.
financing.
The
That's really
reliance
what it
also,
is.
the reliance also is that the municipality continued to take escrow money during this period of time. So for the municipality now to say, oh, your application was dead, but we continue to take
It
escrow,
was in effect.
then, like,
It was
how is that equitable?
permit extension.
Because the engineers kept inspecting the property.
Part of the project.
So that,
What were they inspecting? Because
they did walk-bys.
The engineers, they do drive-bys.
Not the
Just
footings.
means that the-
Well, that was separate. That was done and inspected and approved on both occasions.
And they were approved, I'm sorry, I don't mean that.
No?
All right.
Pretty sure it
So if you didn't have full construction drawings, how do you design footings? And
permits and
um,
approvals.
are you going to continue to use those footings, or will you be removing them?
The footings that are there are going to comply with the new construction. that we
They
have.
will?
Back in
Yeah.
2017.
So would you be able to produce a drawing which shows that those
that's
footings
gonna
tied exactly to your building plans at the time, so that that would sort of convince me that it actually commenced? Because you could drop footings in. So I think that by showing that there were plans, associated with what was approved, then I'd feel a little bit more comfortable about the commencement aspect of it.
Okay, we have drawings and we have the architect who could testify to satisfy your question.
But I asked before, do you have construction drawings? And the answer was no.
Just foundation plans.
Without knowing the weight of the building or the...
Yeah, that's all been calculated, like I said, from after we went from
Okay,
modular to...
I'm going to make a suggestion here, if I may. Ms. Talley and I have been talking about this situation, and it's up to you, obviously, but I think we need to research this a little bit more. And the reason I say that is because Ms. Talley has raised the issue of whether or not the Permit Extension Act might have applicability here. And I think...
I believe that expired.
But not in 2017. That's what, I was going back to the 2017 permit that you were concerned about.
Mhm.
I believe that that permit that was issued in 2017, 18 months after the approval, was because the Permit Extension Act was in effect in Essex County at that time.
Why? That wasn't COVID
It was
year.
from Superstorm Sandy.
Yeah.
Oh, I get you.
The
Okay.
repercussions of Sandy were still in effect through
Mhm.
2017, I believe.
So I have another question. Is there anything in the law that says you can do what they did, put footings in, and then not do anything on the building for 10 years?
No,
You can-
there's nothing that
So people
addresses
can go
that.
buy a piece of land, put some footings in, and then leave it a
Well-
blight in our downtown area for 10
Counselor,
years?
That's their position, that they could put the footings in and that would be fine.
But we, under the law,
Yeah.
the municipality has no recourse to force them to work, or to take over the property, or to force a sale, or
That's-
whatever.
That's certainly one of the questions that I would like to be able to research.
Yeah, thank you.
And look into in this matter. If you are agreeable to working with me, Mr. Massera.
Oh,
we
sure.
could,
I'm just looking, and excuse my phone, but Grok is, or ChatGPT is a wonderful resource. It's not always
I was
correct.
going to say, I was like, I've seen some lawyers get in trouble using
But according to
ChatGPT.
Chat,
This is some judges getting into trouble.
2008 to 15 was the Permit Extension Act. 2012, it was expanded after Sandy. So it doesn't say, I'm happy to confirm.
Okay, we can look into it.
Yeah, exactly.
Yeah, and I'd like to understand more of the concept that council is putting forth of relying on the permit. You know, I mean, is this board more or less bound by the actions of the township where they've issued a permit? I'd like to understand that better.
My position is it's a
No, I
question, it's a
know-
question of equity. I
Yeah.
mean, it's not, there's a case, Verona was the defendant, Chanouche versus Verona, where I think the court said special circumstances that the town was stopped. There's other cases that say a town is not stopped. And, you know, I'll be happy to, again, to confer with Mr. Neese about that, you know, and correspond with Mr. Neese about, you know, about doing it. It's,
I think rather than flipping a coin between the two of us, I think we should look into this a little
Yeah,
bit more.
I'd like your legal opinion for the board, you know, as to what we should and can legally consider here. Yeah, because we're not lawyers, you know, I understand your position as
It's
a
not
as a
easy for
lawyer.
me either, and I am a lawyer. I mean, it's, you know, when there's questions of equity, it's certainly, I think we have met the burden without question. I think, you know, not to repeat everything we have said, I think that we've showed that there is substantial reliance, that building the footings is more than adequate, especially given a case that says beginning, taking out pipes, you know, starts a demolition. And that, you know, unfortunately, this is going to be, you know, a further delay in trying to improve this project, which has already been approved.
I would also like some additional information on the variances and whether they expired or not. I think that's an important point, important question.
I think yeah, okay. I think that goes hand in hand with.
Yeah.
Okay.
And Mr. Neese, to Mr. Ianwale's request about like a certain period of time having that financing in, if you could talk about any sort of compliance measures we can include, so whether it be they must have that financing document in within 6 months and, you know, substantial construction commenced, or construction drawings commenced within a year, something like that.
I'm hesitant to go down that, forgive me, rabbit hole, but if Mr. Massera is willing to make some sort of representation as to what that time frame would be, I think that would go a long way.
I'm not, what I hope to be able to do is to not make the representation and produce proof of financing the next time we appear.
Well, if you and I go through the exercise that I'm envisioning, which is doing some research into these questions, then the next time we get here, there will be, you know, all of this will be presented to the board, and I suppose that would be in and through a written submission from you, as will I, so that we can, so that the board is more educated as to how to treat this very unusual problem.
That's correct, and by then, we'll have proof of the financing. So that's why, rather than make it a condition, it was a concern, and we'll satisfy that concern.
Right, I just don't want that financing to now become used as as evidence of reliance, where I'd like things to remain the way they are.
I can stipulate to that. That's
Okay.
fine. I understand your concern, valid, but totally, totally, it will be submitted as part of this application or part of this request, but not as a means to show that there's an expense or any reliance. The reliance that has been discussed this evening is the sole reliance that we will present to the board.
Which is the issuance of the
past
permit.
practices, well, I mean, with further proofs, of course, but the past practices, and I will be more detailed on what exactly the owner has done and what the owner did in reliance on what has transpired. If we're going to continue, then, you know, I want to be able to obviously present every fact that I have. But here going forward will not be any reliance.
And it's premature for me to ask you, but do you envision that as a certification of some kind from Mr. Coco?
A certification as to?
What he did as in connection with
Yeah,
this
absolutely,
matter.
sure. If that's yeah.
really what I'm trying to get at.
Absolutely.
And just,
Would get building permits and then the inspections of the footings? Is that what you mean?
I think we may have found the tree when I was aiming more for a forest. I'm just talking about what sort of compliance mechanisms we may or may not be able to include in any sort of recertification of this project. So if the board decides that we are going to say, like, look, this does have continuing validity, are we able to put in any mechanisms in that recertification that ensure that work is done? And the answer may be no, but.
I think just off the top of my head, the answer is no, because
Okay.
what they're bringing to you is simply an application, not even an application, it's a request to extend what they already have. That's it. So putting in additional conditions, I don't think is an appropriate response from the board.
Okay, thank you.
go ahead.
I'm not saying in any way that we want to judge what.
I think your microphone's off.
I'm not saying in any way that we want to judge what they have, but we were given one set of drawings, architectural drawings, and the building sort of floats in space. There's no relation to a site plan or survey. I mean, just for information purposes, it might, and also I think it's good for us to, since it's been so long, for the township to understand what was it that was approved that we're approving. So the idea would be to gather up the drawings that were originally approved, site plan, survey, and so forth, so we at least can look at what it is that we are allowing to continue.
Mr. Iannulli, we have those here tonight, and can.
Oh, I think electronically, or if there was just
Well,
a.
can present
No,
those.
more
but
specific
again, I don't-
stuff, too.
See, that's where I run into the issue.
Well, hold on one second. There were resolutions, there were plans that were submitted, there's evidence. In Montclair, our township should have what it was that was approved, albeit there's this one page of changes. But I guess the idea is, we're saying, okay, this project can proceed. I'm not saying anything about changing it, but it would be good to know what is it that's proceeding.
So when I responded to Mr. Macera, I said to myself, well, many people on this board, they weren't around in 2016. They don't know what it was, which is why I said in my letter to him, to Mr. Macera, that the applicant provide the engineering and architectural materials and professionals reports comprising the 2016 site plan approval and all other documents and testimony that will support the request for the extension.
Well, but we're
So
not
do you-
requesting reapproval. And
You're
I don't want-
requesting an
well,
extension.
But respectfully, like, Ms. Loffman.
Can I just, I mean, you completely before I said anything, I said, I do not, it has nothing to do with reevaluating what was done. I just want to know, what was it? That's all.
I'm proud of this project. And I think
All right, well,
super proud.
well,
Like half of your.
Alphonse.
Tony, but I can make, I mean, I have everything in digital form. I can make that, I can upload that to our website and give you access to all the documents that we have.
That's what Arthur asked for, right?
Yeah, so I was trying to simplify it a little bit by just, I was trying to simplify it a little bit by just giving you the architectural plans. If you want everything else, I have it, and I can make it available to everybody.
So we'll see what was approved.
Yeah.
Yeah,
But
absolutely.
just if I can have the last word, I guess. So that building that's back
We'll
there.
see.
That's the, that's the building. That's the building that you plan on building. And there's a site plan that you had submitted that was approved that we have no ability to change. That's correct, right?
Well,
Yeah, and unless, yeah, okay, just so I wanted to.
agree with what you said.
Yeah, but.
Right, because I mean, I think my thought is that whatever it is immaterial to the question that's before us.
No.
I know it's important to the township.
Yeah, I
and it's important
understand
to me as a
that. Yeah,
resident,
yeah. It's, I
but-
just want the residents and the public to know this is
Right.
what's going up there. And this discussion has nothing to do with the look of that building.
But I
agree
think
with
it also, the one point that I think Tony brought up that's very important is that if the footings match the drawings, that does speak to the good faith issue. So I think for that reason, it makes sense to review the plans. So.
Any other last words? Nope.
Sure.
I agreed to do 2 3-bedrooms, not just
Read
little.
the
Oh, okay.
resolution, yeah. You agreed to 2 3-bedrooms.
And Janice, and there was
No.
also going to be additional monetary contribution.
It's not additional, it's what you're required
I
to
know,
do.
I know.
Yeah.
But I was happy to have families in there instead of just 1 or 2 bedrooms. That's why I wanted this to be family.
This is going to be a high rental building. It's in a great part of Montclair. You know, I don't see this as a sob story.
Okay. Just so you know, our next meeting is September 8th. And that's the only meeting we have in September.
I have to discuss with council, we may, I'm not sure whether September 8th will be enough time.
That's pretty
That's-
aggressive from my point of view.
Right.
Then
This is gonna
October
require
6th,
some
this is-
research.
Okay.
Then we have October 6th.
October 6th, I think, is probably what we're looking at, because in fairness, I think both of us to get, I'm briefing this issue, and Mr. Neese is going to respond and then give me his thoughts, and I think we probably have some dialogue about it,
Okay.
so. So it's October,
6.
okay. Okay, thank you for all the members of the board, Mr. Chairman.
Welcome.
Mr. Neese. Thank you.
And if the board has any questions in the meanwhile, please direct them only to Mr. Neese, not to the whole board, and please ask them. Let's take a 5-minute break.
A lot of technical. It is a technical, yeah. And the variance issue is, I still, it's a good one. You go really good things. I agree with you, I think that's.
Yeah, I satisfied myself with that over the weekend.
Yeah, I mean, they're gonna run with it. So the variance question, I think. Not hard.
Hey, that's why I got paid the big bucks, right?
That's right. I mean, we'll approve these things later tonight. I'll keep that in mind when I make a motion later.
Thank you.
It's good work. gavel's next, right?
Yeah, I think so. Ms. Talley, we back on the record? Okay. Is Rick not ready? Oh, I thought Rick was ready. Okay, great. Thank you. Okay, everyone. We are back. Mr. Borshoff has rejoined the dais, and next up is application 2914.
Not with much fanfare.
Wow, but we have to at least say that so it's clear you're back. Application 2914, 10 Hartley Street. Ready when you are.
Thank you, Mr. Chairman. Good evening, everyone. Alan Trembulac appearing on behalf of the applicant, 10 Hartley LLC. This is a continuation of the hearing on the site plan application involving the property at 10 Hartley Street. Just as a brief recap, as you'll recall, this property is located in a redevelopment area which is designated by the Township Council actually back in 2002. Redevelopment plan was subsequently prepared and ultimately adopted by the Town Council, I believe in 2007, if memory serves me. So the development of this property is subject to the requirements and the regulations contained in the redevelopment plan, what's called the redevelopment plan for the Elm Street/New and Mission area. As the board will recall, my client purchased this property, which previously contained a church which had been abandoned and vacant for several years, demolished the church building and proposes to construct a four-story multifamily building containing 3 apartments. The application complies with all of the bulk requirements set forth in the redevelopment plan for this property, except for the lot size and the lot width, which are 2 things really beyond our control. This is an undersized lot. And there's
Mr. Trembulac, please hold for 1 second. I think someone closed the doors because of the noise, but we want to make sure it's clear this is a public hearing. So Mr. Neese will kindly reopen the doors for us. One of us always does. Like sometimes Vice Chair does it. All right, Mr. Trembulac, sorry about that.
No problem, Mr. Chairman. As I was saying, the plans that we've presented conform to all the bulk requirements applicable to this property, with the exception of lot width and lot area, because it's an undersized lot, which is a condition that's existing today, and that there's nothing we can do to change it, although my client, as you'll recall, indicated that he did approach the property owners on both sides of his property on Hartley Street in an effort to see if there was a possibility of acquiring their properties, and those discussions went nowhere. So the only 2 variances we need, again, are for lot area and lot width. There are 2 waivers that are also requested, one for the width of the driveway. It's a one-way driveway leading to the rear parking area. The requirement in the I guess it's in the site plan ordinance, is 12 feet, and we're proposing a driveway width of 10 feet. The other waiver is for the amount of landscaping required with respect to the property. At the July meeting a month ago, we presented the plans through the testimony of the project architect Ryan Robertson of GSA PC, the project architects. He also responded to questions from the board members, questions from members of the public. And in response to some of the concerns which were raised at that meeting, Mr. Robertson has prepared some plan revisions which we'd like to review with the board tonight. Following his testimony, we will then present our second and final witness, our professional planner, William Stimmel, who will testify in support of the variances and the waivers. So, having said that, I'd like to recall Ryan Robertson.
Mr. Robertson, you recognize you remain under oath?
Yes.
Thank you.
All right, Mr. Robertson,
And
since the last meeting in July, you...
Mr. Trembulac, should we mark your new exhibits?
I was about to...
Oh, perfect, thank you.
reference them.
Let me add that, because we have had reports since, we got to mark the new plans.
Sure, let me hand you these. These are
Okay.
the-
PowerPoint.
The revised PowerPoint.
Okay, so A12 are the revised plans prepared by GSAPC, dated August 8th, 2025. A13 is the report from the Planning Department dated August 13th, 2025. A14 is the report from the Board Engineer dated August 14th, 2025. A15 was the list of changes to the plan that were submitted by GSAPC dated August 15th, 2025. And then this PowerPoint presentation will be A16.
Was that list provided to the board?
What?
The A15 list of changes?
I emailed it to the
was.
board members.
Yes.
Yeah.
Do you need a copy?
If you have one, yes, please.
I think I have an extra copy here.
Okay, so if I may, Mr. Robertson, since the July meeting, you prepared and submitted to the board revised plans for the application, correct?
That's right.
All right, and those plans are dated the revised plans are dated August 8th, 2025, correct?
Correct.
All right. And you've also prepared a PowerPoint exhibit to assist in your presentation of those plans for tonight's meeting?
That's right.
Which has just been marked as A16. So what I'd like you to do is to review the changes to the plans utilizing the PowerPoint exhibit that's, I believe, ready for your presentation on the projecting screen.
Thank you. Okay, so as Mr. Trembielak said, I've got a few supplemental slides to the testimony I gave last month, which will address some of the discussion items that were brought up by the board members. Slide 1, this is the previous rendering, which remains unchanged. It's the proposed east rendering, but I include it here to point out this area here where we had a planting box. I think it was Mr. Chairman that pointed out that we were calling for plantings in this location that needed full sun. And so we made a revision there on the east. This is the east facade, so it would only get full sun at part of the day. So on your sheet A004, which was one of the revisions, you'll see the revised planting schedule where we've swapped out the previous plants located here to be 14 golden star plants. These are evergreen shrubs which will produce a yellow star-shaped flower mid-spring through late summer. They grow 6 inches to 8 inches in height, and they thrive in both partial shade and full sun environments. Slide 2 shows an amended lighting plan, which is also part of your package. These 8 lights here that are indicated in black text are what is new. The red is what was previously there, and those were as a result of the board's comments. We included 2 new lights designated W1, located behind the roll-up door, to provide some additional illumination where there was inadequate areas previously shown. And we also worked with our lighting designer consultant to update the values in the parking area, showing 6 fixtures labeled S1, 3 on this side, 3 on this side. And that is this fixture here, which is a square recessed fixture mounted inside the masonry portion of the retaining wall that we described last month. It's 8 3/4 inch by 8 3/4 inch. It'll be mounted at 2 feet high. And I included on the slide here, which would be on the handout of the presentation there, shows the height of those 3 of the 6 lights mounted at 2 feet. And the applicant was happy to add these 6 lights as a way to improve visibility and safety concerns raised by the board, especially in consideration of maneuvering around this tight lot, particularly at night.
Mr. Robertson?
Yes.
Can I just ask you a question? So, as you go into the driveway, is there overhead lighting for
Yes.
the cars to see where they're going?
Yes.
Yeah.
Those 4 actually were there before, and then there's 2 new ones. So those are recessed lights.
Yeah, so it'll be amply lit for them
That's right.
going into. Thank
Yep,
you.
Thank you. On this next slide, we have a small change to the 4th floor, which is located right here. This is the north-facing facade, which is important because that was an area of discussion last month. We've added an additional north-facing terrace right here, and it's approximately 25 square feet. There's already a south-facing terrace in this master bedroom, but we decided to add another one as a way to help improve the look of that north facade, which you'll see in next slides. In order to achieve that change, we swapped the configuration of this bathroom, put the shower over here, moved the door so that we could get a door to a new terrace. And here on this next slide, you see that additional 25 square feet right here at the top floor of the north facade. It's kind of effectively widens the carve-out here to provide some visual depth. 4 of the 5 terraces, you see 1, 2, 3, 4, now include an integrated metal planter box for tenants to put flowers or herbs or other plants of their choosing. These planter boxes will be designed into the railing system with removable trays, will be designed such that the planter boxes do not project beyond the property lines.
And they're affixed to the railings?
Yeah, they'll be integrated into it, made of the same material,
Okay.
except for the removable trays.
And then one other minor thing, the ladder on the eastern side of the north elevation.
Right here.
That goes up. And I don't think it's a purview of this board, but when I saw that, whoever's managing this property, let them know they need additional fall protection, because that's not a fall just to that platform, it's a fall off the side of the building. And
Okay.
that gave me some concern.
Okay, sure.
And Ms. Lockman, or Councilor
Oh.
Lockman, did you have a question or comment?
Yeah, I was just wondering, looking at the north side, is the building, it's built right on the property line? So that
Yes.
if the building, the lot to the north of that, somebody builds something, they can go right on the property line as well?
Yep, currently that building to the north, which is Lot 8, is, I think, 12 inches off of their own property line.
Yeah, okay.
Is that the gym?
That's the gym, yep.
Yeah.
And we have some information on that coming up in some slides here. In addition to making the changes to the elevations, we decided to add some color because there was some trouble, I think, understanding maybe some of the depth and some where the pushing and pulling happens and how this looks visually. It just helps, I think, to have the color. So we did 4 colored elevations that you have in your package. These are just 2D renderings. No changes were made to the east facade here. I think the board will have been able to imagine how that looked based on the rendering, but the other elevations are better understood with this color palette. So on the south, you see the 2 planter boxes in black. We still have the gray brick at the base, the red brick in the middle portion, anywhere that's touching the property line, and anywhere that's set back is the wood or simulated wood rain screen. And these are all set back 5 feet, those alternately colored areas. And at the top is the same metal parapet as previously proposed, but we've carried the brick across the top too for horizontal band.
Mr. Robinson, just a question for you?
Yeah.
So you're saying that there's that, the yellow on the right-hand side picture, that's going to be like that simulated wood grain?
Mhm.
Formerly, it was brick?
No, that was always.
That was always there?
Yeah, it was. It was just hard to tell in the drawings, I think, so that's
Okay.
why we colored it.
So is it that color that's going to be,
It'll be a brownish color.
and the brick itself is a reddish color?
It's a reddish color, right.
Okay, thank you.
And you don't have a palette of these colors, do you?
No. Like material samples, no, but we could provide them to the board as a, condition of approval if needed.
Sometimes that's helpful for the hearing, just to, when you're trying to convey certain colors to the board, sometimes it's helpful, clearly not for tonight, but for future use,
Okay.
bringing those.
Okay. Okay. Here is the west and north elevations. Let's see. The west, which is the rear, is mostly that rain screen material. There's been no changes to these elevations, just colored. The north elevation does have the 2 planter boxes and this additional area that we talked about. And on an upcoming slide, I'm going to show you what this facade will look like from Bloomfield Avenue, because I know that was a concern.
Just a
last-
question before you move from this
Yes.
slide. So the cornice at the top, what material is that? Is it brick, or is it that, simulated wood?
No, this is metal.
Oh, it's metal.
Metal at the
okay.
top, and then brick. This height is brick, the
Okay.
red brick. And the same thing here, it carries through the same height all the way on all 4 sides.
Right, and it's just very simple, there's no
Yes.
design element, yeah.
And again, this rendering, we pointed out last time, this is deceptive. You wouldn't actually ever see it like this. None of this gray brick would be visible anywhere because of the gym adjacent to it, and the height of the gym is somewhere here. But we'll look at this when we look at the Bloomfield Avenue view.
And is that just cement block?
That was gray brick.
What?
Full brick in a gray color.
Oh, okay, thank you.
To match what we had at the front.
Is that microphone actually on?
Yes, does it?
I think it is, yeah.
I can hold it closer, is that better? Okay, this slide, we wanted to prepare an exhibit to help illustrate what, in our opinion, is the suitability of the scale and proportion and height of the proposed building in the context of this redevelopment zone. So, as we previously testified last month, 6 stories are allowed here at our site, and we are proposing only 4. 67 feet height is allowed, and we're proposing only 48.5. Hartley Street is a narrow one-way street, and so when imagining this building in a 2D streetscape and only thinking it on Hartley, it's kind of hard to imagine the true impact in the neighborhood. So we think this aerial photo showing the context tells a more accurate story. And we calculated all the heights here based on the measuring tool in Google Earth. So letters A and B, right here and here, are the Charles H. Bullock School. The high roof right here is 47 feet, so roughly the same height as our building, our proposed building, with a tower at the corner of the building that is 10 feet taller than our building right there, at 58 feet tall. Letter C is the property at 180 Bloomfield Avenue right here, which is 42 feet tall. Letter D is the Gospel Deliverance Center on Hartley Street at 39 feet at its highest point right there. Letters E and F are the building at 192 to 194 Bloomfield Avenue, which is 48 feet tall with a 60-foot tall design element emphasizing the corner here. And letter G is the vestry building at 147 Bloomfield, which is 64 feet tall. So, given the surrounding site context, we would offer that the proposed height of 48.5 feet is appropriate in regards to the surrounding context. And in fact, the next slide is an image from the... Yes.
Yeah, that's...
Really?
That's the existing. This is the existing Google aerial photo. Yeah.
The church that was demolished, right?
Yeah.
Yeah, that's,
Right.
that's the,
It's 48 and a half feet. That's how I was.
That's
I
the
had
proposed.
The
is
same
48.
reaction.
Yeah, sorry.
What
I should've
size are
mentioned
you? What height are you?
We're going to be 48 and a half.
48 and a half.
What was the height of the church building?
I don't know the height of
Oh,
the
okay.
church building.
Okay.
So are you
30.
presenting another version of this with your building inset?
Only viewed from Bloomfield. Yeah.
Why show this without your building?
Well, I didn't have a 3D model to place in here, I guess.
But I mean, a schematic of sorts, right? I mean, because it looks like your building would be just as tall, your proposed building would be just as
A.
tall as A.
As A, right.
The Bullock high roof,
Right.
and frankly, taller than C, and C looks fairly tall.
Right. I'm showing it related to the area that's unshaded out. This is the redevelopment zone. This is where we're trying to fit into, and I'm trying to show, if you can forget for a moment that this is the existing building.
I think
that
that's
what
the
we're-
hard part. I get what you're trying to show, but you're trying to show how your new building fits with the redevelopment zone, but you're not showing your new building.
I think another slide will do a better job if you.
I don't, yeah, I was like, this gives the wrong image, sorry.
Okay. Well, here's an image from the redevelopment plan that we pulled because it showed kind of two book-ended buildings which are even taller than that building which is labeled C. The reason we include this is because, let's see, those appear to be about 5 stories each, and this seemed to be what the authors of the redevelopment plan envisioned for this area. Even taller buildings at the 2 corners, which I still think is appropriately scaled for the neighborhood. Next.
So that's just, you're saying from the plan is what they suggested could be built, is
Right.
what they were saying? Okay.
Right, that's all I'm mentioning there. So here I want to discuss the visual impact of the building when viewed from Bloomfield. Blue is our subject lot here, 10 Hartley. Since the last meeting, we've been retained by the owner of 8 Hartley, who has been interested in this application, has been watching with great interest. He's probably watching right now. We have a signed agreement with him to look at this to build 2 stories on top of the existing building. So we have the opportunity to show you what that would look like from Hartley. Or, I'm sorry, from Bloomfield. Which is this. That's page 10 of your handout. So this is a composite image of the Google Street View with 2 3D models placed on top. And in the distance you see R10 Hartley. You can see the 2 recessed cutout areas that we talked about. This is the one to the east. This is the additional 25 feet. And in the foreground is another massing model showing the existing gym, which is that bottom line right here, and adding 2 stories. The face of what you see here is the existing north face of the gym, but that building's only 26 feet wide, and the lot itself is about 48. So in reality, this face of this building could be pulled towards us closer than it is shown in this image, which would further obscure 10 Hartley. And
So I'm not sure I'm following this. So the 3 rectangles I'm seeing there are against 10 Hartley? Is that on the property line of 10 Hartley? And you're saying it could come all the way out past the gym? Is that the state?
On top of.
I'm saying this bottom mass right here
Yeah.
is the gym. The other, the side that you're not seeing is where it is right now, 12 feet off of its own property line, 12 feet off of 10 Hartley's property line as well. But this face is not maxed out. This face could pull 20 feet towards us, is what I'm saying.
It could be pulled
If
towards,
they
but it could
wanted
also
to.
go against the 10 Hartley, right? It could go
It
right up against
practically is
it.
right now. It
is
could
right
go
now.
another 12 inches, but you
Okay.
wouldn't really see it here.
So on your slide number 6, if they do this at 8 Hartley,
Yes.
as you're proposing in slide 10, that's going to obscure all of that north elevation.
All the way up to the top floor, because they're only adding 2 floors where we have
Right.
3 total.
They had the option to go 6, correct? If they wanted to?
Yes.
Yeah.
And if they went 3, they could still in the future go up 3 more stories,
Yep.
right? Okay.
Mhm.
So slide number 10 is not quite, well, you don't know what's going to be built there, but it shows that you can see the top of 10 Hartley.
Right.
But that may not be the case at all.
Well, we happen to know what the applicant for 8 Hartley wants to. They only want to add 2 stories at this moment, but you're right. They could change their mind. and they could want to build higher. But this is just to show, the board had wanted to see what this would look like from Bloomfield. So you can imagine it without these two boxes on top and the gym remaining. Sorry about that.
I think it would have been helpful to see that, right? That was kind of the question of what does it look like from Bloomfield Ave? It would have been helpful to see it without the proposed massing or the potential massing. Because, I mean, you could have put 6 stories on it, and then we wouldn't see 10 Hartley.
Right. Okay.
Well, you can see what the facade is going to look like. And if the building is built on 8 Hartley, the only thing that would be visible from Bloomfield Avenue would be the 4th floor. And I thought the board's concern was that they wanted the plans to comply with the design guidelines, not only facing Hartley, but also facing Bloomfield.
Correct.
Even though a good chunk of the building may very well be shielded from view from Bloomfield Avenue.
I mean, it might be, right? I mean,
It probably will be, based upon what's apparently going to happen on 8 Hartley, so.
well, they would still have to come before this board, correct?
8 Hartley?
Yes.
Oh, yeah,
Yeah.
yeah,
So, I mean,
yeah.
they seem a little bit earlier on in the process, and I appreciate what you're trying to say, but, you know, I'm looking at this I personally am looking at this application for what's there now, you know, and what is, because who knows who constructs first? We just sat through an hour of, you know, an application that was from 2008 and still hasn't been constructed yet. So, you know, I appreciate what you're saying and what you're trying to show, but for me personally, I would rather see it without the additional massing at 8 Hartley, so I could see what does 10 Hartley, what does your proposed building look like?
But it's on
Isn't
there.
that what
Yeah,
we're showing?
yeah.
Slide 6?
I agree, that's.
Kind
this
of.
is-
It's kind of what you're
nice-
seeing on slide 6.
But if
Except the line
that's
is-
the point of putting in in slide 10, if your point of slide 10 is what does it look like from Bloomfield Ave, I'm saying that doesn't help me, because that shows another project.
Well, I think part of it is you were concerned about it being too blank.
Correct.
Mm.
And it
so-
still looks blank.
Right, right.
But-
Yeah.
And
You're
you said
saying-
you were going to put in some brickwork, right? Is that still what you're proposing?
Yeah, we're still
or-
doing a horizontal brick at the top now, and we've widened one of the terraces. And then we're engaged with the neighbor, and we decided to show the board what the massing would look like. That was the intent of that.
I have a question.
Yes.
I guess I'm back to my usual. If you know at this point that someone is applying to build a building that's going to be on the property line right next to that building, and you have the 3rd floor, you have a balcony there, which will be obscured by that new building on 8 Hartley, why on earth build a balcony when you could use that space inside the building for a closet or something more useful than a balcony that's going to be in the dark anyway? I just don't get
Well, I
it.
mean, I think it's debatable if a closet's more useful than an outdoor amenity space, but,
An outdoor that's hardly an amenity if it's up against a wall.
well, not right now. But look, he just said it might not be built.
Oh, but
Yeah.
Round and
it's
round we
hardly
go.
theoretical.
Which is, I think, is the concern.
Yeah, yeah,
Theoretical, right? So
right.
Probably shouldn't be looking at the theoretical building at all.
Okay. Yeah.
And one more question, though. Sorry, if you know that this owner next door wants to build a building, I'm befuddled that you wouldn't combine the 2 lots and build a better building, which would have, which would look better, and you wouldn't have these 2 strange buildings.
Combine 8 Hartley with 10
Yeah,
Hartley?
the 2 of them combined, you could build a better building, I think, if you had the 2 lots combined.
I kind of agree, and I
Yeah.
think if you recall, Mr. DeSanti testified at the last meeting that he approached.
And they didn't want to do
He
this.
didn't want, he had his own plans in
Yeah.
mind and did not want to combine the lots or do any kind of joint venture. And
He didn't.
similar conversation with the owner on the other side.
That's-
12 Hartley.
But now you know that the owner 8 Hartley is interested in building. Maybe if they're listening to this, they might consider, combine the 2 buildings and make a much nicer building. Anyway, enough said. I'm sorry, I just.
I think they all have different concepts of what they want to do, different personalities, different ownership, different concepts. you know, you got a gym on the property, as we're, you know, 100% residential.
Could they build a balcony that faces into that balcony, like right there? A serious, like, I'm very curious. Could they do that?
And there, will they?
No, could they?
Yeah, that could be a flat roof back there.
So they could have two balconies just right up against each other? Like, I'm a serious question. I mean, because the concern we have is that the building right next door can go right up to the property line. So I know it's hypothetical, but it's very concerning, all the permutations that could occur at 8 Hartley. And on the other side, too, at 12 Hartley.
But again, 8 Hartley will presumably come before this board if they move forward with plans. And I'm sure the board would remember this conversation and others if that should occur, to make sure there's compatibility there.
Yeah.
Well, this redevelopment plan was never, this is more of a comment, this redevelopment plan was never put in place to do the size buildings. The
Yeah.
requirement was 15,000-foot lots. So if it was done as an overlay, where it's overlay if you have 15,000 feet but have R2 stay, then you'd be able to have a properly proportioned building on a lot. So this is really hard because
Yeah.
we're saying that the redevelopment plan's intent is different than the result of the variance that's being asked for. So,
Yeah, that was the
I don't-
concern last time too, Tony, right? It was that it's a lot to fit into a small lot. The parking is a concern, the turns that the cars have to make. And the fact that, you know, the light could be all shut off by 6-story buildings were all major concerns last time.
is there no way to consider I guess the redevelopment plan is a complete replacement of zoning, right? It's not an overlay.
It's a complete replacement.
Okay.
That was it for the presentation.
But did you want to talk about the balcony and the terrace?
What did you say?
Yes.
Yeah, the applicant is happy to lose this terrace if the board wishes. If that is, like Ms. Laughlin says.
What are you going to do to make that side look interesting? It might be covered up.
Yeah, yeah.
I mean,
know,
this is my
but-
concern. Is
No,
that
no, I get you.
if
Absolutely.
8 Hartley doesn't
If we don't approve it.
materialize,
Mhm.
this is a really blank wall. And I appreciate that you colorized it, Mr. Robertson, because it helps me see what it is, but it makes it look more blank, unfortunately.
Right.
And you said you were going to put a soldier course at the top? Or are you going to do kind of banding in the middle?
No, this is,
Sit at the top.
this above, right there is all brick
Yeah.
at the top. And then metal at the very top.
I mean, it would seem you would need something kind of in that left-hand side to break up the flat, all-red brick.
Soap suds ad?
I mean, I heard last hearing, we're not doing murals, so, you know, I won't raise that again. But, I mean, it looks really blank for the downtown. And I'm really struggling with that.
Yeah, I mean, but we'd have to come back and show you.
Have we heard testimony with respect to the variances that are being asked for from a planner? I forget it.
It's next. The
Oh.
next witness is the
witness.
planner, so we'll
Okay.
discuss variances and proofs.
Are there any other
Question.
plan revisions that you haven't already discussed? No. Okay.
I guess you're not going anywhere.
I guess I'm out of luck on any sort of north elevation design changes.
Well, I thought I heard the owner say that they're willing to change the color of the brick, if that would help.
Maybe, but I didn't hear Mr. Robertson say
Yeah,
that, so I
but-
wasn't sure.
Well, yeah, we could change the materials, we could change the orientation of materials. I'm not sure how to present that, though. Can it be
You want to come
condition
back
of
to the
approval that
revisions?
we do is there a
Yeah.
subcommittee that can review?
Revisions,
Okay,
yes.
yes. Then
Absolutely.
We're happy to do that.
So you'll
for
come
sure.
back with some ideas and go
For
through the
sure,
revisions?
yes.
Okay,
Yes.
great.
I don't know if you know Pine Street, there's some great inspirational brickwork done on some of those buildings there that were built by the Italians at the turn of the century. It's worth looking at maybe some of those, right?
Okay.
That's your old neighborhood.
They're not, there's space in.
But in the front, they could mimic some of that.
Do you have more testimony, or should I open it to the, okay, questions from the board? No questions? Is there any member of the public that wish to ask this, step right up to the lectern? Since you're the first person, please make sure the light's on. Wait. Are you sure? Can you just push? It is? Okay. I'm not.
Push. Okay.
There
yeah.
we go.
It looked bright to me.
It deceives a lot of people.
Yeah.
So if you could just restart, I'd appreciate that.
Bonnie Fogel. I live on Forest Street. I'm right down the street from the lot that they want to develop. So.
Not this
Mr.
lot, you meant
No.
the last
Well,
application.
Mr.
wanna make sure.
Robertson, I want to guess you don't live in Montclair Center.
I don't.
No, because you said you thought it was appropriate, and people who live in Montclair Center don't think it's appropriate. So here's my question. It doesn't look like there's an elevator in this building. So I'm just very curious as to what this is about. How is this building making Montclair better in any way? I'm in my 70s. I'm going to go live in a third-floor walk-up? Excuse me, I waited a long time to get a first floor in a walk-up building. So this is not helping older people.
Well,
This has no outdoor space. This is a building.
This needs to be questions. And I know
Okay.
you asked one question. I'd like to have Mr. Robertson answer
Okay.
it. If you
Okay.
have, and you can
So-
keep asking as many questions as you want, but in terms of opinions, that'll come later. in the
Okay,
hearing.
okay. So, I guess this whole business, I've always been under the assumption, because I want to believe the best of people, that when provisions and standards are decided, they're based on a lot of hard work.
Is this a question for Mr. Robertson?
Oh, for Mr. Robertson?
Yes,
Oh.
yes, these are questions for this witness, Mr. Robertson, who
Okay.
just testified. So
Okay.
if you have questions
So-
about his
so-
testimony.
Okay, here's my question. The recommendation for the metal planters, where did you get that recommendation from? From what
The
kind of
recommendation.
person? Somebody who has anything to do with planters? Because in New York City, where I'm from, the metal planters that exist in commercial areas exist in a way that they are groomed and replanted every couple of weeks, because it's such an undesirable material to use for planters. So while your design idea might be that it looks good, it actually creates an incredible expense to maintain them at all. So I'm just curious where ideas for things come from, or is it just because you've seen it and you think it's a good idea?
No, I mean, our firm has landscape architects on staff.
And they
so
recommended metal planters.
We came up with that idea, yeah.
And was there discussion about how they're going to be maintained so it looks so it's maintained properly?
Will it be maintained by each tenant? So that's.
Oh, okay. You answered my question. Bingo.
Thank you.
So.
Thank you.
Are there other questions from the public for this witness? Yes.
All right, I actually have a list of about 35 questions, so I have to find the questions for the architect. Well, the first question...
Ma'am, who are you?
Oh, sorry, Sarah Avery, Montclair resident. I live on Irving Street. How can the applicant request variances from a redevelopment plan that requires all development within the development area to meet the provisions and standards? Page 30, provisions and standards on the upper left, strategies on the upper right. General requirements, last sentence. All development within the redevelopment area are required to meet the provisions and standards. And if you go to the page The next page, provisions and standards. That is where the lot size is defined. So how do you have a variance when the redevelopment plan, which is the zoning code, how do you ask for a variance?
For the architect?
That's what I'm asking.
Well, I think it's a question more appropriate, it's a legal question or a question for the planner. And I'm happy to answer it as a legal.
Sure,
because
good.
It's really a legal question.
Okay, you can
It's no
answer.
different than the zoning ordinance, because as you said, the redevelopment plan serves as the zoning ordinance.
Exactly.
And just like property owners and applicants have the right to request variances from the zoning ordinances.
Okay.
They have the right to request variances from the redevelopment plan.
Does
So
the
that's
zoning code of
That's the
Montclair,
legal right under New
does-
Jersey State, can I finish? That's the legal right under New Jersey State statute that governs all land use applications in the state of New Jersey. So that's where the authority comes from.
does the zoning code of Montclair say that all plans are required to meet the zoning code? Does that say that in the Montclair zoning code?
Indirectly, the zoning ordinance creates standards for all zoning districts, which must be complied with unless the applicant applies for and proves his entitlement to a variance under the state law.
Yeah, I disagree, and,
You disagree that the board has the right to grant
no.
variances?
The plan, which was approved by the town council, let's jump to that. Let's jump to that as long as Mr. Trembulac is answering questions.
Legal questions.
Yeah, yeah. Well, here's a question for the township planner. Why did the planner state under oath that the 2006 redevelopment plan was before her time?
This isn't questions for the board or the planner. These are questions for the
Mr.
witness
Robertson.
about his testimony.
Well, when
in the
do we
matter.
have an opportunity to question the other persons who are part of this application who have taken an oath to tell the truth? When you're giving me an opportunity to question the witness, the architect, I will do so, but I would like to know when the public will have an opportunity to question Mr. Trembulac and the planner, because they have taken an oath.
First of all, I haven't taken an oath, nor have I provided testimony in support of this application.
Well, the planner has. All right, here's a question for the architect. Why doesn't the proposed building facade have any historic character?
It's a new structure. Is that what
Okay.
you mean?
Yeah, but the redevelopment agreement requires the development to have character that conforms to the architecture of the city of Montclair. So why doesn't the proposed building facade have any historic character?
Can you
It's
point
a
to the provision
yeah,
that you say requires that?
Well, it's a 61-page document. I'll have to go back to my seat so we can return to that question. At the last meeting, the architect claimed, because this came up in the last meeting, where you said, Mr. Robertson, that, we tried to design the building so that it conformed to other properties in the neighborhood, but there weren't any properties that were in the neighborhood that we could use. So my question is, why didn't you visit the Montclair Public Library to study the historic character of Montclair architect when designing the proposed building?
I believe my answer, where I said there was nothing adjacent, that was in relation to the datum heights that we're required to relate to. There's nothing near us to the east, or I'm sorry, to the north or the south to relate to datum points, and that's what you're referring to.
All right, well, my question is about the historic character, because the 2006 redevelopment plan definitely requires it. And, then my follow-up question, why didn't you go to the Montclair Public Library? If you were unable to go to the library, why didn't you contact the local librarian to investigate local historic character rather than design a modern facade with no historical character?
This building's not in the historic district. We're required to follow the design guidelines, which require us to use a color and material palette, similar to adjacent buildings. And we did. It recommends wood, brick, and stone, and we've included those.
Yeah, here I have it. This is from the tape. The architect claims there were no buildings nearby they could use as inspiration for building something with the character of the neighborhood. I mean, that's what you said. So that's why I have those two questions. And let me see if I have any other questions. I believe you said that there were 5 trees that were removed?
There are 5 trees planned to be removed. That's right.
Right. So you have to plant 5 trees, right? We have an ordinance in this town where you remove a tree, you have to plant a tree. So you have like almost 0 pervious coverage. So where are you going to put those 5 trees?
I'm not aware that we're required to replace with 5 trees. We were doing a street tree.
Yeah, well, I don't know why, that hasn't been communicated to you, that we have an ordinance. When you remove a tree, you have to plant another tree.
Doesn't necessarily have to either plant a tree or make a contribution to a fund to provide trees on other locations. I believe that's what the tree removal ordinance provides. And we have to comply with that ordinance, and we will.
I'm looking for the page where it says exactly what was supposed to happen on 10 Hartley. Yeah, so let's see, page 60, for each property, was specifically identified, and there are recommendations for each property. And 10 Hartley, the recommendation was that the existing structure be rehabilitated. So why was the existing structure, which the plan designated for rehabilitation, why was it demolished?
There was a hole in the roof, and it was collapsing according to the applicant.
In fact, if you read this redevelopment plan, the church on Hartley, it is specifically referenced as having been recently renovated. That's in 2006. And the plan specifically says that building should be rehabilitated. And I don't think, a response that there was a hole in the roof when the roof could have been repaired that's not a sufficient answer.
Well, first of all, it's a recommendation. It's not a requirement of the plan. It's a big difference, ma'am. You can laugh. It's a big difference. And also in 2006 and 2000, when my client purchased this property, the church had been vacant and abandoned for several years. It was deteriorating, and it did not appear to be appropriate for rehabilitation. He was not required to rehabilitate it. It was a recommendation of the plan, not a requirement.
At the last meeting, Mr. Robertson claims, and again tonight, Mr. Robertson claimed that the applicant is permitted to construct a 6-story building on this lot. But if that's the case, and you increase the number of units and the number of bedrooms, and 1.9 parking spaces are required per unit, where would you put the required 9.5 parking spaces? If what you say is the truth, that a 6-story building could be built, where would the required parking be?
We would have to ask for a variance, and that's part of why we didn't.
Are there any other questions from the public for this witness about his testimony? Actually, I see two people coming up.
Mr. Tremblay, just confirming that your microphone's on, and if
Yeah.
you can move it just a pinch closer. Thank you so much.
Sure.
Good evening, ladies and gentlemen. My name's Dave Herron. Just have a few questions. When did you actually purchase this property?
That's a question for my client.
1 year ago.
Thank you. Question on affordable housing. I don't remember hearing anything about having any apartments that are going to be affordable housing.
There's no affordable housing proposed for the site. It's not required. The redevelopment plan makes reference to the existing inclusionary zoning ordinance and essentially took the position that that was adequate, that nothing additional was required, at least for this portion of the redevelopment plan. So the town requirement, as I know you know, Mr. Herron, is one unit, one affordable unit for every 5.
Correct.
This is only three dwelling units proposed for this site, so there's no affordable requirement.
Okay.
And forgive me, I'm confused. I thought the applicant's representative testified about affordable housing at the last hearing. He said that it's not required.
I don't know if he testified.
Yeah, he
but
did.
it's
It was
not-
the first question.
Oh, okay.
Yeah.
Yeah, okay.
I remember.
And mentioned that the idea of it would be fair market value,
Right.
equivalent to the costs of the apartments and the dwellings in the area.
Yes.
Okay, right now, no more questions.
Thank you.
Thank you.
Good evening, Janet Hubert, 5 Ward Place, Montclair.
I'm sorry, what was your name, ma'am?
Janet Hubert.
Hubert?
Yes.
Okay.
I have a question for you. You said something about the character of the neighborhood. What would you describe as the character of that neighborhood?
Can you remind me what I was referring to when I said the character of the, I think I was probably talking about the height or the scale of the building.
The character, if you understand what the word character actually means,
I do.
it's the essence of the neighborhood. What would you say, as the architect designing this, is the character of the neighborhood? If I may ask, because you talked repeatedly about the character of the
I
neighborhood.
don't believe that I did talk about the character of the neighborhood. I don't remember saying that.
Well, that's what I'm asking you. You said you designed this thinking, well, looking at it, I'm trying to understand how you came to this design based on that neighborhood and that location where there are, it's very, very small. It's very tight.
We came to the design based on the design guidelines in the in the redevelopment plan here, starting on page 50.
May I ask you your experience in design? You're an architect.
Yeah.
But you are, I don't want to be insulting at all. The design is a design, it's very bland, it's very basic, it's very nothing. It doesn't look like anything in the neighborhood. Your experience as a designer, the difference between a designer and an architect. You're just basically building a box. It looks like a box. Why did you not consider some character?
I think we have differing opinions about character and design. I don't have an answer for you.
Okay, well, that's going nowhere. So I have one more question to ask you. In that neighborhood with the torrential rains, the other day, it was raining so hard, I could not believe the flooding that was happening, trying to get home on the south end. Where is the stormwater going to go with such a density of such a small space? Do you have a catch basin or something that you're building? Where is it?
Yeah,
And there's a garage, right? Proposed garage.
Not a garage. There's a rolling garage door to an open drive aisle, so it's not an enclosed garage. It just gets you to the backyard. And that's where the drainage is handled, is in the backyard. There was a drainage and grading and drainage plan submitted to the town and approved by the engineer.
But there's a lot of flooding going on, a lot of historic flooding that we've never seen before. Are you considering a little better design? Because I'm not seeing designs, I'm not seeing
Well,
architecture.
If I can jump in, there was a grading and drainage plan designed by a professional engineer, not Mr. Robertson. It's designed by Petrie Engineering, which calls for an underground detention basin in the rear of the property with piping that will take all the water from this property out to a catch basin near the intersection of Hartley Street and Bloomfield Avenue. That's been reviewed by the gentleman sitting to your right there, the town engineer, who has provided a report to the board in which he indicates that he found that plan to be acceptable.
What about is there a state engineer? What is are you, because we went through this on another application, I just wanted to, understand where the extra water would go. Okay.
I've explained it as best I can. Mr. Hernandez, the engineer, can discuss that with you. It's on the plans.
Okay.
And again, he's approved them.
One last question. What is who are you trying to appeal to with this architecture? Who is your buyer for something so very basic looking? It's supposed to be luxury, or is it?
I'm not the property owner, so I don't have a buyer.
But you're the architect. Yeah. Who are you trying to appeal to?
My client.
Oh, okay. That's not me. Okay.
And he expects to, just so you know, he expects to maintain this property and have it as a rental, not sell it.
Okay. Thank you.
Thank you.
Thank you. Are there any other members of the public that wish to ask questions of Mr. Robertson about his testimony?
Good evening, Nicole Farjani. You talk a lot about 8 Hartley and the possibilities there. Who owns on the other side?
To the south of 10
Yeah.
Hartley? I'm not sure. The applicant has been in contact with them, though.
And I can tell you also,
Okay.
because I've spoken with that woman years ago. Her name is Mary. I can't remember her last name, but it's owned by she owns that and the 2 adjacent properties on the same side of Hartley in the name of an LLC. I think it's called Mares, M-A-R-E-Y, M-A-R-E-S Property Group, something like that.
I kind of remember hearing about that. So she owns the 3 adjacent properties to the south. That's what you said?
Yes.
Okay. So when you guys, I can't address you. I'm curious because you're, with some knowledge, I guess, from the owner to the north, you made a drawing to show what it could look like, possibly, but it could be higher, because he could go 6 stories as well, and Mary, or whoever the owner is of the other, could do the same.
That's right.
So, with that knowledge, my question is, my question is, with that knowledge, how do you ask for variances as such and not think that either side could come to the board as well and ask for the very same thing, and then what you have basically is row housing? I mean, that's what it would look like if everybody said, ooh, look what they're doing. I plan to do it as well. The windows, everybody laughs, but it's not funny if somebody builds next to it and then it just blocks it in like that. So the design, I did go over to Hartley to see, it is very small. So I would just think, this seems bulky, and did you take into consideration that both sides could do the same thing?
Yes, we knew that when you build to the property line, any property owner adjacent can build to their property line by right. And so we knew that.
By right or by variance?
By right, probably, by right or by variance. Well, what do you mean?
Because you're asking for a variance for for that, right?
Not to build up to the property line, no,
Not to
we're allowed
build
to
up-
build up to the property line.
And what is exactly the variance for?
Our variance is for the width of the lot is undersized,
Mhm.
and also
The overall size of the lot.
Yep,
Square
the square
footage
footage of
is
the lot.
also undersized.
Okay, thank you.
Thank you.
Any other questions from the public? Okay, perhaps two more. Thank you.
I just had a question based on what she just asked.
Okay.
You said that the lot is undersized. Why can you not conform to the size of the lot?
It's
Wouldn't
been
that make more
subdivided to a
sense?
certain size, and the zoning describes what you're allowed to build to a certain sized lot, and our lot just happens to be smaller than that size. So it's an existing condition of the lot.
Understood,
Okay.
understood, but it's a tiny neighborhood. It's a small, tight neighborhood. You're basically doing what New York has done on the West End Avenue, where they promised they would never build and block the view of everybody else who was on the West End Avenue, and she's correct, we could all do it. Why can't you just come in and build something beautiful and it conforms to the size? You would have much better response.
All I can say is we disagree in terms of.
Is it money?
Conforming.
Is it all about money?
No, it's all about.
But what about the people who live there, who live right next to this monster, this big, I'm sorry, it's kind of.
Well, right now, nobody lives next to it because there are
But-
3 vacant lots, and on the other side is a gym.
Understood, but it's Hartley, it's still a neighborhood, there's a church, it's still a neighborhood, it's still within the neighborhood. Is it possible that you might redesign a little bit to conform to the neighborhood?
I mean, we've got an application before the board, what you see. That's what we're hoping to get approval on.
Okay. I'm sorry, I just had to ask it because she brought it up. And we were just wondering. Thank you.
Hello, everybody. My name is Lynn Stockhammer, and I live on Forest Street. And Janet Hubert, I had a very similar question and a couple of other questions. I'm trying to read my notes, so forgive me if I'm not looking at you.
That's
And
okay.
my notes are all over the place at this point from this long meeting. I just don't understand. I'm back to a similar concept in terms of having heard that this was an undersized lot. Well, this is the lot that you have, and that you said there's nothing we can do to change it. Build smaller. Janice Talley, at the earlier hearing that we had tonight, said that on Orange Road, that there were changes made to the rooms. So why aren't there three-bedroom units made smaller so that the applicant would not need so many variances? I was also looking at, can you answer that?
I'm sorry, can you repeat that question? That you said the three-bedroom? We don't have 3-bedroom units.
Well, why aren't the units made smaller so that the applicant, so that you would not need so many variances to ask, so that it would fit on this, quote, undersized lot, which indeed it is? There are problems with the width of the driveway. You're asking for that. And I'm just really learning about redevelopment plans and the provisions and standards, but it seems to me that there's just an exceptional number in terms of the sizes and the variances, the minimums that exist and what you're asking for. This property is 30 feet wide. There's a deficiency of 62.5% for what you're asking for, and the lot size has a deficiency of 77%, being that it's 3,399 square feet, which is a deficiency of 11,601 square feet. I think you may have addressed earlier, so forgive me if I'm asking this question again, but I had seen page 30 of the provisions and standards that Sarah Avery referenced before, and it states that all development within the redevelopment area is required to meet the provisions and standards and design guidelines within the redevelopment plan. How is it legal for the redevelopment plan to allow to ask for variances?
Again, that's a legal question, which I believe I already answered, and I'm happy to answer it again.
Please do.
The state law, the state statute governing redevelopment, as well as the municipal land use law governing all land use applications in the state of New Jersey, allows an applicant to request from the planning board or the zoning board variances to deviate from the required standards. And that's a matter of state law, which applies to this application.
Okay.
And if you look at the end of the plan, it makes specific reference to the state statutes, which again, give any applicant before this board the right to request variances.
Well, somebody
To meet
that I-
certain proof requirements in order to establish a right to them.
Okay, I was advised by somebody who knows a lot more than me that this application should not have been submitted by the Development Review Committee on the basis that this application does not meet the provisions and standards. But that's fine. I think that this may have been mentioned by other people before, but there are 32 mentions regarding affordable housing in our plan, and I just see nothing here that is helping Montclair. And I'd like to know if there is consideration other than your profit motive, which I understand people are in business and this is what people do, but there are also people who are trying to live. And I think that there's a moral obligation on the part of the town that people's lives and our neighborhoods and our character and our standard of life are more important than trying to squeeze a behemoth into a tiny space that's just inappropriate. And I would like to know, and this has been asked of you earlier tonight as well, are there any other motives? Is there any consideration of the Township of Montclair? You come in, you come out, you make your living here with your clients. You've sat on boards here as well. Are there any other considerations for human beings who are trying to live in this town and all of the human beings who are being pushed out of this town? Is there any?
Is that a question for me?
It's
or
a
the
question
applicant?
for whoever would like to
Well,
address it.
well-
I understand there's a profit to
I'll
be
address
made.
it.
I
Yeah.
understand that this is
Sure.
life.
This is, as you acknowledge, a small piece of land and a small building. We're creating 3 dwelling units for people to live in. With respect to affordable housing, as I said before, there's no requirement in this plan. The town did not impose a requirement for affordable housing, separate and apart from the general requirement that 1 of every 5, if we were building 5 apartments, which we can't because the property
Right.
doesn't, accommodate 5, then we would have to provide an affordable.
Okay, well,
But-
I'm sorry, go ahead.
Well, I can't answer it any more than that.
All right, well, you've declared that this is an undersized lot. You're saying that you're providing housing for 3 families, 3 units. The families that I know, I'm sure you've been in this town, you've represented people in this town for a very long time. Who are these? And I'm not objecting to people moving, from place to place if there are people coming from outside, but who are these being built for? It's not the people of Montclair.
I'm not sure what
Well,
what you mean by that,
who
the
are you
people of
who are you aiming at? Who are you aiming at with market value?
market value rentals.
Thank you very much.
We got 2 more coming.
Hi, my name is, can you hear me?
Yes.
Hi, my name's Mariah Askew. I live on Willowdale Avenue. Because you're an architect, I'm going to ask you, you've been here around for the past 10 years, yes?
10 years in Montclair? Are you asking 10 years? No, not 10 years.
How much?
I've been working in Montclair since 2019.
Okay, cool. So, you know what gentrification is.
Hmm.
Can you elaborate?
No.
Wow, okay.
I mean, ask me, I don't know.
Well, what that has to do with this application now.
So as we all can see, we can see that there are large levels of gentrification within the downtown Montclair area into the South End. Although, as an architect, you don't have to build affordable housing, you chose not to. So I want to know why that is. Because we don't need more luxury buildings. We need buildings that are affordable so that people like me and my family don't have to forcibly be removed. So I want to know why, even though you didn't have to choose, you chose to build something that isn't for me or the black and brown people that lived and grew up and built that end of Montclair. So if you don't know how to answer what gentrification is, and you don't know how it has affected the black and brown people within the downtown and south end of Montclair, then why are you building in that area? What are you trying to contribute to the black and brown people who live in that area?
I'll answer that, ma'am. We're trying to redevelop.
And please don't call me ma'am. My pronouns are he and him.
Okay. We're trying to develop this property consistent with the goals and objectives of the redevelopment plan that has been in place for 20 years, which unfortunately I don't think has produced any new redevelopment in this area. We're hoping to, perhaps start a trend to accomplish some of the objectives of this redevelopment plan. And what we're proposing...
You're not answering my question.
I'm about to, and we're obligated to comply with the redevelopment plan, and except for the lot size requirements, which are out of our control, we meet the requirements. The requirements do not impose any obligations on the applicant to provide affordable housing.
But you're choosing still not
That's correct.
to offer affordable housing.
That's correct, which is
and
our
so
legal
people
right.
like me are being, it's your legal right.
You're suggesting
It's your legal
that
right, but you
we're
don't
not-
care about the people who are being
That's-
kicked out of South End Montclair and downtown Montclair. So
That's-
why would you not want to contribute to affordable housing when you have the power and money to do so? And you clearly don't know how to answer that question. And so I have nothing else to say.
It's really not relevant to this conversation.
It's relevant to this
It's relevant
conversation.
to a bigger issue.
If you're
that
embarrassed because you
goes
don't know
far
how to
beyond
answer
this
the question, that's
application.
not my responsibility. I asked a question that you don't know how to answer. If you don't know how to define gentrification,
No, it's up to your counsel.
Let the applicant answer your question.
Sure.
Yeah, it's up to your counsel.
Sir,
My
before
name
you
is-
answer, you recognize that you remain under oath from
Yes,
the
sir.
last hearing.
Yes.
Thank you.
So I'm first generation born here. So I know the pain. I grew up in the city of Patterson. I grew up in the ghetto. Okay?
in Montclair,
In Patterson.
I'm asking, did you grow up in
And then I grew
Montclair?
up in Montclair, but please, just, I don't look at brown, black, Asian, any color. 'cause I
Everybody
don't see-
does.
I do, but you have to just understand.
But I don't want you to say that you don't
I don't
acknowledge
see
the
color.
racism. You don't see color?
I do not see
I
color.
could see that you're brown, you could see that I'm black. What do you mean you don't see
But
color?
you have to understand. We
I
came
don't
in here to this
understand how you
country
don't see
with working
racism.
hard. All I look at is the American dream. And the only thing I
And the
ask from
American
anybody here
dream
is a piece of the
only
American
works
dream.
for the
Because
cisgender,
all I ever
rich,
ask for is
and
an
white.
opportunity
It does
to
not work
advance.
for people
That's it.
like me.
But that's not right.
Yeah, it isn't right.
No, but this doesn't apply
It
to
isn't
this
right.
application, ma'am. Or he, whatever you want to be called. But
It's how I should be addressed and deserve to be addressed.
so be it. But
So be it, so now you're transphobic.
I just want everybody to understand that, we're a family of Italian immigrants. We came to this country, okay, in search of a better life. Doesn't matter any gender, race, whatever. We all came here living for one
And
goal.
that's the point I'm
and
trying
that's
to
the
make, is
American
that
dream.
you don't want to make it
And that's
about
all I can say to
racism.
anybody.
You don't
And
want to
this
make
is
it
an
about
opportunity.
homophobia.
I've
You don't
worked
want to make it
21
about
years
transphobia.
to
You
provide
don't want to
something
make
for
it
the
about
family.
any of those
And that's
things,
all I ask.
even though those are the things
And I
that affect the
understand.
people in this area.
Okay, I
He
think,
tried to answer the question.
I think
She doesn't
everybody's
even
made
allow him to
their
answer the
point.
question.
Do you have other questions for Mr. Robertson?
I did, and none of them were answered, which exactly proves my point. You do not care about the gentrification within downtown Montclair and South End Montclair.
Excuse me, questions. Do you have any more questions for Mr. Robertson?
That was my question that didn't get answered.
I understand it didn't get answered to your satisfaction, but do you have more questions?
No, because that's embarrassing, that they don't know how to answer that question, but they're building on the
But
land.
I understand. You've made your point, and I think we've heard it. Do you have more questions for him?
No, no
Okay.
questions.
I think there was another person who wanted to come up and ask questions.
I'll take this.
Well, and just a reminder, these are questions for Mr. Robertson about his testimony. Okay, so if he didn't testify about certain topics, and as important as they are to the township and to the residents, it's not appropriate to try and ask him now.
Good evening, I'm Nicole Grimsley, 5 New Street. It's where I reside. So my concern is, we know that it's a very small area. And again, what's been said over and over again, that it's going to be a very large development for a small area. My concern is with the safety of vehicles coming through that area. Do we know what the square footage is, curb to curb?
Square footage, curb to curb?
Yeah, I'm concerned
We testified
about
last
that.
month about that.
Okay.
Yeah.
I'm sorry, I wasn't.
I'd have to look it up. 24 feet.
24.
Curb to curb.
So would that be adequate? Would that still?
Well, cars drive through it now.
Yeah, but there's often a lot of cars illegally parked, as we know. Already, that's a situation.
It's a legal street, and, cars go down the street now, and so there's enough room for cars to travel the street, and if there's going to be any development on Hartley Street, it's going to obviously utilize the same road that everybody else currently utilizes, which is narrow but adequate.
Okay, thank you.
Sharon Smith. I'm on Bloomfield Avenue in Montclair, right above Hartley, so I'm familiar with the area. I drive down Hartley all the time. My question is, and I had notes and I threw them away, when you was given the testimony about the heights of the building in the area and the character of the neighborhoods, you gave examples of places that's not on Hartley Street. You referenced Bullock School, which is on Washington Street, which is a very wide street. You gave examples of a couple of different apartment buildings along Bloomfield Avenue, which is a very wide street. My concern is Hartley is a small street. It's a small lot. The building is going to come out, I guess, to the sidewalk, basically. Why so tall on Hartley Street? It's going to overpower the street. There's going to be no sunlight because the building's going to be so high, you're not going to get no sun on Hartley anymore. You said the character of the neighborhood. Mission Street, New Street, Washington Street all have two-family homes. Whatever happened to building two-family homes in Montclair that looks like a house? Born and raised in Montclair, living here all my life. We used to have neighborhoods with homes. Even when they built them, they brought them in on prefab, I can remember as a child, and built them at looking like houses. Why all these buildings all of a sudden on our little side streets?
I mean, the zone allows for 6 stories, and we didn't want to build 6 stories. We built less than that, and it allows 67 feet tall, and I understand the concern about the scale. The image that you were talking about earlier where I showed the other ones around the area, I was showing the context of other buildings that are part of the redevelopment zone. Because at the last month's hearing, there was a member of the board that was concerned about the sense of scale on 10 Hartley. And as I said in my testimony today, when you think about this just as a 2D streetscape on 10 Hartley, that's one thing. But this is also a redevelopment zone. The town is trying to spur development. So we tried to show the context of the rest of the area. So that's all that exhibit was showing.
Right, and I understand that, but why so big? Why can't you build it 2 stories instead of 3 stories? Why
We
does
could.
it have to be so tall? Even though the ones you say was around the areas, it's not on Hartley Street. Our side streets along those streets are all 2-family homes. So it's not the character of the neighborhood. That's definitely not the character of the neighborhood.
Right, the
You get the
zones,
character of the neighborhoods on Bloomfield Avenue where you have the buildings going up all over the place. All around me, buildings are going up all around me on Bloomfield Avenue. However, on those side streets, they're family homes. You don't find too many buildings on those streets.
right, because that's an R2 zone.
I don't know anything about zones.
but-
I don't know anything
but
about variances.
that's the issue. That's the issue, though,
this is-
because R2
This is
zone,
planning for dummies for me.
Yeah.
Because I don't know anything. I just know what it looks like and how it's going to look like an eyesore sitting on Hartley Street.
right, so the zone always butts up to another zone, and there's an R2 zone just right there between Hartley and New Street that butts up to a C1 zone, right? So that's a commercial district right next to a residential district. That sort
Right.
of thing happens all the time, and this lot happens to be very close to that border.
I understand that.
yeah.
But, okay, so, and I understand you have a job to do as the architect to do what the developer is asking you to do, but I don't understand why so tall and all the way out to the street. You can't even walk down the streets now because buildings are all the way to the sidewalk.
Thank you.
I just have a process question, because I haven't been to a planning board meeting in REL Extet. When does this open up for general comment as opposed to just questions?
I can take that one.
Okay, thank you.
So after the applicant has gone through all of their expert witnesses and you get a chance to question each one of them along the way.
Aha.
And then when they basically say they're not quite there, that they're done, after all their experts, then the public has a chance to make its comments about whether they feel positively or negatively about the application. At that point, you can say, within reason, but just about anything you want about the application.
Thank you.
You're welcome. We still have more folks ready.
Okay, I have one more question because, you're saying that, you think the design of the building is very nice and you don't have to have any affordable units, but the plan also discusses the relationship to the objectives of the plan, which is maintain Montclair as a desirable residential community, accommodating a range of population and income groups. So tell me, how does your design accommodate a range of population and income groups?
Can you tell us where you're reading from? It's in the redevelopment plan?
Yep, page 56. It also says, ensure that new development is harmonious with existing development in scale and style, and does not harm the quality of life of surrounding neighborhoods. And one of the other people, members of the public, who came up here to ask you questions, spoke to this point. Harming the quality of life of surrounding neighborhoods. Several people have brought that up. And your response to every person who has come up and asked you that question is to be dismissive.
I'm not dismissive, I just don't believe that it's injurious to the neighborhood. I don't know.
But you have people coming up here to the microphone who live in the town, who are telling you that this development, the type of development that you are proposing, has harmed and is injurious to the population of Montclair.
And that's for the board to consider.
That's a matter of opinion, ma'am, respectfully. And just to point out, you're reading from the portion of the plan that discusses the relationship between the redevelopment plan
Oh, yeah.
and the town's master plan.
That's right.
And talks about the consistency.
That's right.
Okay, yeah.
Yeah, that's what
Okay.
we're talking about.
Yeah.
Some consistency here. Okay?
Where?
Because it also says preserve the rich architectural heritage of the township. And the design that you have presented does not do that.
That's your opinion, ma'am. Do you have any special expertise in
Well,
design?
Aren't
hang
I
on.
asking the
I was gonna say,
architect?
let-
Am I not asking the architect
I understand, but
questions?
my point is this, it's about questions right now. okay?
Because I
And so-
do have questions for Mr. Trembulac. And this is, you have advised me prior to that this is not the appropriate time to question Mr. Trembulac, so I do not understand why Mr. Trembulac is addressing me when I have not asked him a question.
That's why I stopped them.
Okay, thank you.
That's
I
exactly
appreciate
why I
that.
stopped them. You're.
Okay, appreciate it.
Hello again, Lynn Stockhammer. I just had a question regarding Ms. Sharon Smith's questions about the zoning. Is Hartley Street part of the R2 zone that requires two-family residential units, or the garden zone? Can you explain that, please?
A portion of Hartley is the R2 zone. And a portion of Hartley is the C1 zone.
Well, in the redevelopment area.
And we're in the redevelopment area, yeah.
Is that the same as the garden zone?
No, that's different.
Okay. So is part of this building in the two-family residential unit, or are you squarely in the redevelopment zone area?
Squarely in the redevelopment zone.
Okay. I have a comment which I'll phrase as a question so that perhaps it can be answered, but I would really like to know why two grown men cannot answer a question and address
That's
a
not
member of the
that's not
public
a question
here.
about his testimony. I'm sorry.
Okay. Thank you.
Through. Any other members of the public wish to ask Mr. Robertson questions? I don't see anyone.
Okay.
So, Mr. Trembulac, I was going to hear from your planner this evening, and even though it was getting close to 10 o'clock, but given the amount of public comment that I expect here, I think it's wise to continue this to another night. If you're agreeable to that, bring your planner back for their testimony, and then allow enough time for the public to make their comments.
Understandable,
Thank you.
yes. And, yeah.
I
like
think
to
it's wise at
that
this
no
point.
good decisions are made after 11 o'clock, and that would be the
Or
case here.
possibly even 12. Ms.
Bill, are you available September 8th?
Ms. Talley, what's our date?
And that works for us. Our planner's available. I'm available. We'll be back.
Okay, so this application, so the public knows, this application will be continued to September 8th. No further notice will be published, and you'll consent to the extension of time?
Oh, yes, of course.
Okay. Anything else we need? Yeah, well, so now we're all set with them. I've made the announcement for 10 Hartley, and so that leaves us to deal with application 2931, 400 Orange Road, which I would also like to continue to a future meeting.
We'll get out of the way here.
Thank you, Mr. Chairman. Gregory Massara on behalf of the applicant.
I'll make sure we can get you on the microphone.
Thank you, Mr. Chairman. Gregory Massara on behalf of the applicant, 400 Orange Road. We certainly consent to allowing more time for the board to consider the application.
Is there anything else on September 8th? I think we could, hopefully on September 8th, we could at least start
Get
400
your
Orange
started.
Road, but I leave it up to you. I mean, you've seen.
It should be a very Two-witness application, no variance is required.
Yours may be quick, I'm not sure. I believe your property had some public interest. The last time there was a development plan
We
put
believe
forth.
we've satisfied the public's concern. I'm just saying.
And maybe you have. I'm
We
just
believe.
saying,
I said we
it looks
believe.
like we've got 2 applications with significant public interest. I leave it up to you if you'd like to try for that night, or if you'd like to schedule for
Well,
a future.
based on what I have, would you know how many witnesses Mr. Trembulek has left?
He has one more
Just
witness.
the planner and then,
Correct.
I mean,
And then public comment, and then board deliberation, which,
Right. Right.
it could be significant.
what are the other alternatives?
Well, we only have one meeting in September, so the other night's October 6th.
I think we'll try for September 8th. and
Okay.
then- Okay. Thank you, Mr. Chairman. No further notice required?
Correct.
Thank you.
Great, thank you.
Mr. Becerra, do you have a moment before you leave?
Okay, do we have any committee reports?
Well, I do want to report that my staff has been working on preparing the next step for the master plan. We have to first do the master plan reexamination report, which I'm hoping will be not too extensive, because we're going to, I believe the intent is to move quickly into a comprehensive update to our land use and circulation plan. So, and we're also working on zoning changes, that we've been talking about. So we're working on a lot of those things. What we'd like to do is schedule a meeting at the planning board to talk about planning issues, to talk about the properties where we see changes occurring, because we kind of know where the pressure points are in Montclair. So one of the things that we've been trying to, and we also have to bring back the discussion on the climate change-related hazard vulnerability assessment.
I can't hear
Hey,
you.
folks in the back.
Sorry, we also have to bring,
Folks in the back, if you could have your conversation outside of the room or quieter, we'd appreciate it so we can keep going.
bring back the new and improved climate change-related hazard vulnerability assessment. So I'm trying to get a date for that, and I was just to reserve for master plan discussions.
So Janice, just a question about the master plan. Are we hiring a consultant to do the master plan?
I want to frame the project first. So that's why.
That's the discussion that'll take place here.
Yeah, and bring the public in, get public input as well.
Okay.
And that'll help me frame the extent. I started off looking at parking. I don't think that the parking evaluation will need to be as in-depth as I started, and so that's why I'm just trying to get an idea of how to frame it and what experts we need to bring in.
Thank you.
So, and I also want to bring up these properties that we've talked about, and invite the representatives from those neighborhoods to come up with some ideas, what they think. I mean, we've talked about the DeCamp bus station property. And when a developer told me he wanted to put mini warehouse there, I was just like, it just doesn't seem like that's a good fit for that location. So we are looking at the zoning. We want to frame, it's just one example, so I just really want to get a broad discussion from the planning board and from the public as to, do you want to see continued mixed-use development there? We did talk about an opportunity for affordable housing, so those are just some of the things that we'd like to talk about in a workshop. I've had my staff come up with an idea, and they thought maybe we could do this as a workshop setting, break up into, not a formal meeting, but break up into working groups and talk about all these different ideas. So anyway, that's kind of what I'm trying to look for, a date in one of our meetings in October.
And so that'd be a formally noticed meeting?
It would be a
where we do
notice
that?
meeting,
Okay.
but we would structure it as a workshop. And maybe break out into working groups. I don't know if we can do that.
At a public meeting, no.
All right.
I wouldn't advocate for
Then I will tell my staff, who have all these wonderful ideas, that maybe we could do it a little bit differently.
We
but
may have to do it with just a subsection of the planning board.
Yeah. But we can actually do presentations on these different areas
Mhm.
in a more formal setting and maybe have subsequent meetings, okay? But again, I just wanted to kick that off and bring them into my staff, into the discussion. My assistant planner, who's got a certain qualities, and our economic development coordinator who's doing certain tasks as well. So that might be October 20th.
Okay.
Since we have a, well, I'll work on that.
Since likely one of those
I
applications
know.
will-
I'll have to reach out to whatever date we may have to continue, Mr. Macero would be available, so
Right.
that we're not conflicting. Okay?
Well, he may
So-
be sticking around, so you may be able to
Yeah,
catch him
yeah.
this evening. Okay.
All right?
We also have bills.
Motion to pay the bills?
Well, in light of your glowing reviews on 161 to 167 Glenridge, I would motion to pay the bills.
Second. All in favor?
Aye.
Opposed? Abstentions? Okay.
I would move adjournment.
Second?
All in favor?
Aye.
Opposed? Abstentions?
Have a good night, everyone.
Thank you.
You got good
Great
reviews on it.
job.